Hi, everybody. I'm Wes Wollenweber. I'm with a firm that practices all over the Front Range, Colorado Springs, all the way up to here. And I had to look at the screen for a minute to see what we were talking about today because I thought it might have been Biology 101. I'm usually not in a room like this. I've seen a few of your faces over at the municipal building. I think some of you have maybe taken the little 1 hour fair housing block that goes with the 4-part series. Those classes always kind of remind me of speed dating, like one person comes in and then another. And that's what I'm used to doing, but I do teach longer version fair housing like the one we're going to do today, but I'm usually in a smaller room, and I like to really do interactive things, so we're going to have to see how that works with this type of setup. Some of you today, I may make property managers who aren't property managers. I may make a few of you, bring you into my world, and even make you a lawyer for the day. Because the way I like to teach fair housing is to make it as interactive as possible. And I'm all mic'd up today. I'm not used to being on a microphone either. So everybody hear me okay? Okay, if it gets too loud, let me know, and I can actually adjust it from up here. Well, I've been teaching fair housing for a number of years, and I absolutely love this area. It gets me away from the conflict of what I do for a living, which I'm a trial lawyer, so I'm always dealing with angry people in conflict. And what do you think is probably the main thing I really dislike the most about being a lawyer? Dealing with other lawyers. It gets really tiresome after a while. And I was just telling Ginny Sawyer, I love getting out of the office to teach this class. So, okay, you're like, hey, Wes, that's great. So glad you love this subject. What are we going to get out of it for 3 hours this afternoon? And I want to thank everybody for being here. It takes a commitment to do that. But before I tell you what I think you're going to get out of it, let me kind of get a sense who all's here today. Raise your hand if you do manage rentals or multifamily communities. Okay, quite a few of you. Okay, good. Who owns their own properties and kind of runs them? Even more. All right. What about housing authorities? Do we have anybody here from local housing authorities? Okay, what housing authority? Fort Collins Housing Authority. I'm really glad you guys came. You guys have probably had some fair housing instruction over the years. Yeah? Well, I'll try to give you some of the more complicated issues that we're going to cover. So we have quite a mix, ranging from people who manage subsidized properties. At the Housing Authority, do you guys have a mix of communities, tax credit, Section 8, things like that? Okay, good. That's going to make this class a lot of fun because we're going to deal with every kind of housing this afternoon that I can think of, except maybe homeowner associations, but that could even creep in. We have one member in the class who not only manages rental properties, but she also manages HOAs. And fair housing is applicable to every single type of community that's represented in the room today. So what I think you guys will get out of this is, one, you're going to get some good education and some real A to Z type of stuff. This is a basic fair housing class. You might in the first 20 minutes think it's a history class. I'm going to kind of share with you where the law comes from. But the first thing I hope you really take away from this class today is we all know education leads to knowledge, but knowledge leads to power. The power to prevent things from happening to you, your community, your owners, your bosses, that might lead to some kind of legal liability. Two, when you really know fair housing and really understand it and really embrace it, you're a major asset to your employer. You're a major asset to yourself if you run your own property. And you're a major asset to your owners if you manage for owners. The third thing, which is the most important to me, I love to try to get across the point that the more you understand fair housing, even though it is so much about the rights of people who rent properties, apply for properties, buy properties, live in communities, the law is there to help people who manage, own, and run properties. And we're going to explore that today too, how fair housing will help everybody in this room build a stronger community and be stronger at what they do. I know when I first started taking fair housing classes, because we didn't always teach them, and I felt like I needed to know about fair housing, I would walk out of the classes feeling like fair housing was just a ton of do's and don'ts. But that's not, we're going to talk about the do's and the don'ts today, but I don't want you leaving the room thinking that's really what fair housing is. It's much bigger than that, and I want you to leave feeling like I'm starting to really get it, and I know how to apply it, and it's there to protect me as well as my community. You were with me, sir, in the 1 hour block. We hit on some interesting issues. We're going to expand on those today. And you brought up a great scenario that you had. So any of you that, as we go through the slides in the material, if you feel that you've dealt with the situation very similar, just raise your hand. We want this to be a participatory class, highly interactive. If you got questions, definitely ask them. I'm usually pretty good at spotting everybody's hand. You got the books that will track the slides. Everybody found where the copy of the slides are? And those are where you can take notes. And at the end, we've got some newsletter articles that senior partner at my firm and I have written over the years that are pretty relevant fair housing topics. Let's start with this. Who's managed property for over 3 years? Okay, quite a few of you. You have? Okay, what's your first name?
Donna.
Hi, Donna. You look kind of familiar. I feel like maybe I've met you up here. Donna, what's your sense of what fair housing is? Just give us a one-line definition of what you think it probably really means. Okay, so Donna said, fair housing has the word fair in it, so we'll start there. I taught a class last year with a tenant advocate, and I was surprised to hear her say, what's so fair about fair housing? And I kind of laughed because sometimes property managers, owners don't feel like all the law's fair. But I love starting there because we're going to talk about how the laws got created, and the idea was to make things fair. Were things fair with our housing in the 1940s, the 1950s? And a lot of you shaking your heads no. We're going to talk about that in a minute. All right, somebody else that has been in the industry a bit. What do you think fair housing is? Simple definition. Somebody help me out. Who else? One of the housing authority people. You help me out. What's your view of fair housing? You in the purple sweater. Okay, looking at people's needs, making sure things are fair. Who thinks it's about consistency? Anybody feel that way? I'm just trying to get a sense of what you guys already know about fair housing. Okay, well, we'll explore it. Normally what we have right here is a slide of Arnold Schwarzenegger from The Terminator. But I'm not the most politically correct guy on earth, but I thought maybe we should take that slide out in the last couple days. Plus, it was Arnold from The Terminator where he was walking through a bar with no clothes on. So decided to kind of take Arnold out of the picture. But the reason we used to have that slide, it was where Arnold, as the Terminator, had this drop-down, he was a cyborg, right? And he had this drop-down menu where he would size people up. So those of you who manage property, own property, you deal with people all day long, right? They come in and out of your office, you screen their applications, you rent to them, you do maintenance, you take requests that they make. So I guess where I want to start with fair housing is this. How diverse is our society today? Very diverse. So do you have a drop-down menu? Ms. Hernandez comes into your office and do you say, all right, I got to kind of watch my step here. While I don't think Ms. Hernandez is Hispanic, I think that's her married name. I do think she goes to a Jewish temple. I think she has 4 kids, and I think she might once in a while use a cane to get around, so I better watch my step. Is that the way your guys' brains work as you deal with people in your communities? No, I hope not. I know my brain doesn't work like that. I can't keep track of that. And we are going to talk today about what protected classes are. What's a protected class in fair housing? What does that mean? Somebody help me out. Disability, very good. Somebody who fits in the status of disability is a protected class. But what do I mean when I use that term? What is a protected class? I'll have to call on my pal that was in our 1 hour speed class. What's your first name again? Gary. That's right, Gary. I was trying really hard to remember. It's good to see you again. What would you say from the training you've had before is a protected class? Very good. Gary said it's somebody who is in a particular class that the law has said, hey, you can't discriminate against them and make a particular judgment or maybe have a preference about. How many, so we got protected classes, and we're going to talk about what they are today and how fair housing protects people in protected classes. But somebody else help me out. How many protected classes do you guys think there are? Who says 3? 4? Come on, guys, greater than 5? Who says more than 10? Brianna, don't cheat because you've kind of been through these courses. Who says more than 10? Yeah, we're going to cover it and figure out the exact number, but it is more than 10. So are you going to, this drop-down menu, if we really use that in our mind, maybe everybody in the room's in a protected class. I'll bring that back up again in a minute. So the big picture to me with fair housing and defining it is it's not a good way to look at things in landlord-tenant relationships, owning properties, sizing people up that way. I don't know if any of you were taught the golden rule. My mom was pretty strict about it. Just do unto others as you'd have done unto you. I think a great starting point, 90% of understanding fair housing, is just knowing that you treat everybody the way you'd want to be treated. Because if you're consistent and treat people the same, you avoid a lot of the issues we're going to talk about today. So that's really the big picture, treating people the same. One time I was in one of those early fair housing classes, and the lawyer teaching the class said, look, I think I mentioned this in the 1 hour training. If you can discriminate in housing, in rentals, ownership, sales, as long as you don't discriminate against somebody in one of these protected classes that Gary and I were just talking about. How do you guys feel about that statement? You can discriminate as long as you don't discriminate against the wrong person. Common sense tell you that sounds pretty smart or pretty stupid? Pretty stupid? Okay. I guess what I tell you is it's a technically correct legal statement, but as we go through the class, I'll come back to that concept. I think it's extremely dangerous because we are in such a diverse world. Well, the country started out with a real interesting set of what I guess I'd call civil rights laws. Fair housing is a civil rights law, and I want to take a look real fast at where it comes from. So we started out with some real interesting language in the Constitution and then the Declaration of Independence. That was pretty amazing, set us apart from Britain, England. But what was flawed in our first documents as a country? What was the problem? She read the underlined part. Yeah, all men are created equal. How do you feel about that, ladies?
Excuse me.
Yeah. Excuse me. Come again? You want to rephrase that? But that was in 1776. So yeah, what was the other problem in 1776 besides this? Somebody said left out white men. So what was going on in 1776 as we formed a united country? Slavery. Very good. So yeah, we obviously had a long way to go to get up to an era where we started inventing civil rights laws. In fact, 1920, finally, women could vote. Did you guys know it took till 1920? Anybody know that? That's quite a while. So, we had kind of a ways to go. I just think it's really important that we kind of see where we came from a country to understand why we're even here today for 3 hours talking about this stuff.
In New York, Chicago, and Boston, protesters marched, demanding direct federal intervention. Then Wallace made a miscalculation.
So in the 1950s, in the United States, what was going on? A lot of us have talked about it in school. Civil rights movement. And we had marches just like this in places like Alabama. But why was that happening? Why were people in the South marching? Who's ever heard of Jim Crow? That was the lead singer from the Black Crowes, right? No? What was Jim Crow? Wow, dynamite answer. The answer in the back is, one of my hobbies is archery, and that's what we would call a bullseye. That was right on the money. What's your first name? Heidi. Nice to meet you, Heidi. So Heidi nailed it. Jim Crow laws were these laws that we had for quite a while throughout the nation, states where people were separate. African Americans were deaf, blacks were kept separate from the European heritage people, and in many communities, Jewish people did not live next to Catholic people. And this was all part of laws that we called the Jim Crow laws. And these marches in Alabama were to protest that and many other things involving segregation. And it had a major impact on where things were going. Let me ask you a question, then we'll answer it here in a minute. So this was going on in Alabama. Anybody that was up here for my 1 hour class, don't cheat because you might remember the answer. Let's see if anybody else can get it. What state, not country, federal government, what state came up with the first fair housing, civil rights legislation anywhere in the country? Give me some guesses. Illinois. That's a pretty good guess. Why do you say Massachusetts? And the Kennedys are from Massachusetts, right? They are a progressive state. Okay. Okay. Anybody else? Third guess? New York's a pretty good guess. And it was, I'll give you another hint, it was the 50s. All right, I'll answer that in a second. But this is what's going on in the South.
There was tear gas everywhere. You couldn't breathe. You couldn't see. People were screaming. There was blood all out there in the streets. There were horses going over folk, women and children.
Selma, Alabama, I believe 1956, not Baghdad, Iraq. You know, we really had some interesting things going on, marches. And the guy in that white jacket there was John Lewis. I really kind of a civil rights 50s buff, history buff. It's just an era that fascinates me. And he worked for the Southern Christian Leadership Conference, which was kind of run at the time, as some of you might know, by Martin Luther King, his best friend Ralph Abernathy. So there were these marches. And the result of these marches was pretty astounding. What happened after these marches? We started changing some of the laws in this country. That's always interested me because I've done both sides of civil rights work my whole career. I've represented employees in employment cases. And I've had some interesting cases where there's still, to this very day, in the 90s, 2000s, some really egregious discrimination. But the whole time I was doing that, I was defending housing providers, management companies that manage apartment complexes, senior communities, represented quite a few housing authorities and still do, against allegations of discrimination. And it's just been interesting to me. I had a guy represented for a trucking company some years ago. Him and 3 other guys worked in these trailer type things inside a big bay. My client came into work one day and there were 7 nooses hanging in there and some photographs I'm not going to talk about. And when I tell that story, people don't believe that kind of stuff still goes on. I had a case against Quest years ago when Nacho first took over. My client was a female executive who had built up the Dex branch. And when Nacho brought in some guys from the East Coast, they said, "Why do you have women working for you, Michelle, who have robes on?" She said, they're women of cover. They're from the Middle East. Well, you got to get rid of them. You know, that stuff still kind of goes on. It kind of fascinates me. But I think we come a long way as a country. After these marches, some very interesting things started happening. 1965, we had the Voting Rights Act, which led to a lot of different legislation. But let's talk about, where does all of this fair housing stuff we're going to talk about come from today? A bunch of different laws came out right after all of these protests. Equal Pay Act of 1963 prohibits gender-based pay. I've been representing a gal at the post office for 6 years. When you represent federal employees, it takes years to get through their process, but we've been alleging for 6 years that they pay men higher than women. Show of hands, women you feel in management, ownership of property, running government work, women are paid equal to men. Are we there? Yeah, we still got a little ways to go, I think. I see some, nope, we're not quite there. This is an employment law. The case I was just mentioning for the gal against Quest, that was based on this law. And I'd say out of all the federal civil cases of all kinds in the federal courts, this law right here probably today takes up 40% of the court's docket. And, some more civil rights laws all the way up to 1968. But I did ask you a minute ago where you thought the first fair housing law came from. We ventured some guesses: Massachusetts, Illinois, things like that. There there were different laws that came out. We're going to talk about what are the fair housing laws, and then we'll talk about where it all started here in a minute, and maybe I'll blow your mind. One of the first laws in 1973 was Section 504, the Rehabilitation Act of 1973. I'm kind of hoping our housing authority people maybe heard of Section 504. Does that ring a bell? That's because you guys are under that law, and we'll talk about that some more today. That applies to properties that receive federal monies, like Section 8, mod, rehab, properties that get different kinds of federal assistance. And we'll talk about this again in a little bit, but does not mean that if you take a Section 8 voucher, anybody rent to somebody on Section 8, that does not mean you're a recipient of federal money. That'll be important on some slides in a little bit. 1990, Congress came out with the ADA. I'll talk about that in a minute. Who's heard of the Americans with Disabilities Act? Is that the Fair Housing Act? Housing authority people are correctly saying, nope, it isn't, and that's right. It only applies to certain aspects of your property. All right, but let's talk about where does this fair housing stuff come from. All right, here's the answer to that interesting little trivia. Colorado passed the first, I got some interesting looks, the first ever fair housing laws. And for that matter, really some of the first ever true civil rights legislation that people in the 50s were wanting to pass. We passed the Colorado Anti-Discrimination Act, CADA, which still exists today, and it included fair housing laws. Yeah, I was, anybody here that's been around a while, you ever heard of Nancy Snow from the Colorado Civil Rights Division? A few of you shaking heads. We're going to talk today about who the Colorado Civil Rights Division is and HUD. Who's HUD? Somebody help me out. Who's HUD? I know some of you know who HUD is. Yeah, very good. The United States Department of Housing and Urban Development. I like to call them DHUD. Made that joke. I taught a fair housing class a couple weeks ago with a HUD attorney named Jim Whiteside, who I have great respect for, and I always tease him that it's DHUD. Well, HUD is the federal agency that's in charge of the fair housing laws that we're going to talk about. But in Colorado, they have the luxury of having a state counterpart called the Colorado Civil Rights Division, and they enforce CADA, which is an employment and housing law, and they enforce all the federal laws we're going to talk about. So you are working, maybe come from, like me, I'm a native. Anybody a native? A lot of you, wow. We come from a pretty progressive state. We invented the first fair housing laws, and we talked about protected classes. Here they are, the first 4 protected classes. So Nancy Snow was with the Colorado Civil Rights Division for 25 years, and anybody that really knew her, like I do, she was considered the fair housing guru. She just knows everything. She's retired now. She's kind of like my adopted mom. I probably call her 4 times a week just to make sure she doesn't forget her fair housing stuff. And I was at her retirement, and she introduced me to a couple former Colorado senators who, I'm not going to venture their ages, but man, they had to be late 80s. Very interesting guys. And she said they were on some of the first committees that passed the Colorado Fair Housing Act. And I thought, I practice in front of the Colorado Civil Rights Division more than any lawyer in the state. So, as you well know, lawyers can be kind of arrogant, right? So I'm all thinking I'm big stuff. I know my fair housing stuff. So I'm talking to the senator. I'm like, why'd you guys make the Colorado law identical to the federal law? I mean, you could have switched it up a little bit. And he looked at me and he goes, well, Sonny, maybe you need to figure out your fair housing history a little bit. Colorado created the Fair Housing Act, and the federal government just put it in exactly as we did. How crazy is that? I think it's pretty wild. But these were the first 4 protected classes: race, color, national origin, which we are going to talk about all by itself, religion. So Congress, we're going to talk about in a minute, decided they would take this exact law and put it into place. 1968, first federal Fair Housing Act. 9 years later, after all this protesting went on. But I didn't know that literally until 2009, and it just blew my mind. And being a native, I was kind of proud of that. So the federal government put this law in around the same time as those other civil rights acts that we just looked at a few screens back. makes housing transactions subject to civil rights law, holds property managers, landlords, owners responsible for various types of housing discrimination. And these were the first 4 protected classes, as Gary said, people who you could not treat differently. Now, why would Congress in 1968 pick those 4 groups of people? The most common groups that statistics showed maybe had suffered segregation or some form of other discrimination in housing. What was going on in the 70s? Guys, I won't ask the ladies. I grew up in the 70s, so I used to see my sisters thinking they were in Woodstock when they were in Arvada, Colorado, acting like they were at Woodstock. What else was going on in the 70s? What's that? War. What was going on with women?
Women's rights.
Women's rights. Yeah, bra burning. The women were going into the workplace and getting jobs, and they needed to rent. And Congress said, all right, we're going to add another protected class. We're up to 5 now. We're going to add gender or sex. This is part of the Fair Housing Act. So now we're up to 5. Then, several years later, 1988, boy, this is the big law. Congress said, all right, we are going to amend the Fair Housing Act again, and we're going to add some more protected classes. Our senior partner, our firm Marchetter, he calls this the mothership of all fair housing legislation because it added a really major protected class. Out of the 3 bullet points up there, we've got added disabled or handicapped as a protected class, which you mentioned in the front row, right out of the gate, familial status, and it also mentions something about new construction. What do you think is the big one that Congress added there? I know the Housing Authority folks can help me on this one. All right, so I was asking you, out of all these, what do you think the big protected class is? Which one? Yeah, this bottom one means that properties have to be accessible, which I'll comment on in just a second. But out of all the protected classes we've talked about so far, race, national origin, religion, gender, Housing Authority people, out of these up here, what do you deal with a lot? Disabled, disability. We are definitely going to talk about disability today. That was a very important protected class that Congress added, as was familial status. So this is the big law, along with Colorado's, that we're going to spend our time focusing on. But we do have people in the room who fall under the Rehabilitation Act of 1973, and we're going to talk about that as well. So that was where our first fair housing laws came from. 1995, Congress amended the Fair Housing Act yet again and said, we're going to have this law that kind of protects older people in America. And that was because so many people from the baby boomer generation were starting to hit 55 or over. And Congress did some studies and felt like, hey, these are people that have worked their tails off their whole life, and we want them, if they want, to have their own type of communities so that they can be senior-only communities and not be liable for discriminating against people with families that have young people under a certain age. And they called that the Housing for Older Persons Act, known as HOPA. Not OPA like the Greek flaming cheese, but HOPA. So I deal with that law quite a bit because we have senior communities that we represent, and they have to be either 55 and older. Out of all the people in the community, at least 80% of the units have to have somebody in the household who's 55 and older, or they can be 62 and over, where everybody is 62 and older. So that was a new aspect of fair housing. Does it stop with the federal law? We already know Colorado's got one. What about municipal laws? Are there any municipal laws? Let's take a look at that, because there are. We'll see if Fort Collins has one. Under CATA, Colorado law, we protect some other protected classes. So you can't just go by the federal ones, which so far we have race, national origin, religion, disability, familial status, and it mentioned new construction. Anybody here manage a property built after 1991 that's multifamily? Nobody? We all in older units? You do? Okay. If you ever do, and you're in a newer one, the government says it has to be designed a particular way to meet the needs of people with mobility impairments. And I've got an interesting case right now for the first time in years where a condo association I represent just found out that they've got like 17 different things that aren't in compliance with the Fair Housing Act. And we're going to have to figure out how to fix them. And that's an issue for architects, design builders, developers. The builders are really liable for that kind of stuff. All right, so Colorado also protects marital status. What's marital status? Is it Susan, my wife, and I, we're protected under that? Who's single in the room? You're single. Does it protect you? Absolutely. Yes, it protects her, protects me. So, maybe up here in Fort Collins, you might have a landlord who says, I really just like renting to the college students. That's kind of been my forte. I don't really want to rent to married couples who are working, in the work sector. Or vice versa. Maybe he says, even though I'm up in Fort Collins, I don't want to rent to students. That would be marital status discrimination on either side of the fence. All right, question is, a law or an ordinance about 3 unrelated people. Is that a Fort Collins ordinance? Yes. Okay. Every time I come up here, I hear a little bit more about that. And I just had lunch with one of my closest friends that I grew up with, and he has rentals up here and is a psychologist up here. And he's told me about this law. So how does it work? You can't have 3 unrelated people, more than 3. So if you had 4 unrelated people in one of these rental houses that you rent to college students, that would violate the local ordinance, correct? So 2 brothers and 2 friends, it's too many. Wow. Well, thanks for educating me on that. So the question is, how does that apply to this? Well, I know there's been 2 things. There's been talk about whether that Fort Collins law violated any constitutional laws, and I don't think anybody ever found that it did. But what about fair housing? Does it deny anybody in a protected class? Could somebody make out a claim for marital status discrimination? Oh, well, landlord, you didn't rent to me. I don't think you're going to be liable for fair housing because you're going to say, no, I can't violate this ordinance. And we're going to see this with animals a little bit later. You do not have to break a you don't have to break a municipal ordinance or any other law to comply with fair housing. So you would not be violating fair housing by complying with your local ordinance on that. I don't think anybody could get you for marital status discrimination. Is that kind of the essence of your question? Okay. So let's say I wanted to rent from you, and I bring my 3 buddies along. You're going to say to me, you can't do it, right? And we say, he wants married people, or he wants a family, and so he's discriminating against single people. What's your first name? Max. What's Max's defense going to be? Max, what are you going to say in your defense? Max is going to say it has nothing to do, Wes, with the fact that you're single or ugly or chubby. It just is that I have to comply with the local city ordinance. So good, great answer. That's exactly right. So great question, though, because it shows sometimes how local laws can maybe be at opposition with the fair housing laws. Okay, moving to the second one. So we talked about Colorado being pretty progressive. Well, once again, very progressive. We added sexual orientation as a protected class about 2 years ago in employment and then housing. And that is defined to be gay, lesbian, bisexual, or anybody that has transgender type of definition to their orientation. So that was pretty progressive. Denver, the municipality, had protected it, or at least part of that, for some years. But how many people knew that Colorado did that? Anybody? Brianna did. It's because you took some fair housing classes, huh? Yeah, so pretty progressive. Colorado on the forefront. I think, don't quote me on this, but I think we might be one of just 5, 6, maybe a dozen states that have done that. There may be some that have added it to their protected classes that I'm not aware of. But last year there were only 5. So now how many protected classes are we up to when we add federal and state? Quite a few. We're over the 10 mark. And we're not done. If you're ever in Denver County, they add military status, parenthood, which I think is pretty similar to familial status, which we are going to talk about. And hey, look at me, the white guy teaching your class. I'm in a protected class. 40, I'm over 40, pretty obvious. And now I'm in a protected group. So if you remember my point early on, big picture, fair housing, how many protected classes do we have as we've gotten through all these local laws? Let's keep going for a second. If you're in Aspen, Boulder, Crest, Butte, they add political orientation as a protected class. Well, let's talk about Boulder for a second. I'm going to Longmont to teach this exact same class tonight, and I'm going to be mic'd up again there. So I just got to get my hands behind my back and quit touching the microphone. So I'll go to Boulder, Longmont, and there'll be some folks from Boulder, and the folks that'll be there definitely have a certain political affiliation, which would probably be what? Democrat. And I guess it means that in Boulder, they would have to rent to Arnold Schwarzenegger, whether they like him or not, or my boss, Marchetta, who listens to Rush Limbaugh. So far out. I mean, political orientation, age, and family responsibility. So when you lump all these together, we're well over 15 protected classes. So let's go back to that point I made. It's okay to discriminate against, unless you don't, treat somebody differently or pick on somebody in one of these groups as we've gone through the laws that started in 1959 in Colorado. What do you think? It's an awful lot of protected classes. How do you know whether somebody's in a protected class? And should your mind even be going there? Definitely not. I don't think it makes any sense to think like that. I think it makes much better sense to treat people equally. Who has leases that you have to enforce? I would think a lot of you. Who has community rules separate from the lease that you have to enforce? Quite a few of you. And you have to enforce that. How? How do you enforce that amongst the different folks you deal with? I'm looking for a certain word. Consistently and equally and fairly. Excellent. I'll skip Telluride. They kind of repeat that stuff. All right, so we've got some good, kind of basic background. Now we're going to get a little bit more interactive here. We definitely want to talk today about who all's covered under the fair housing laws, what type of housing, what are the protected class definitions, go into that a little bit more, what are discriminatory practices that can get housing providers, landlords, owners in trouble, and who in the room is responsible for complying with fair housing. Let's start with what the federal law, as well as the Colorado law really, says it's illegal or unlawful to do. Can't refuse to rent to somebody in a protected class. This is the big one. And if you were in my hour class, we did talk about this briefly. You cannot discriminate in the terms, conditions, or privileges associated with a rental. Terms, conditions, privileges. Sounds like Charlie Brown's teacher talking at you, doesn't it? It is kind of legal mumbo jumbo. I mean, they're plain words, but what do they mean? Terms, conditions, privileges. With rentals, what does that refer to? Somebody help me out. What do you think a term, condition, or privilege is? Oh, I love that example. So say you get an applicant that you're a little iffy on. They're in a protected class or otherwise, and you say, normally I'd get a $500 deposit, but I'm going to do $2,000. Is that a term, condition, or privilege? $2,000 security deposit versus a $500? Absolutely. It's everything that you guys deal with. Your lease terms. Who has amenities at your property? Who has an exercise room? Swimming pool? No swimming pools in the room? Wow. What are some benefits I would get if I rent from you guys, besides a unit or a house? Mary? Good management. Well, then I'm in pretty good shape there. Good management. Parking? That? Excellent. All right, and we'll see if that's a term, condition, or privilege here in just a minute. So let's review real quick. Here are the first four protected classes: race, color, religion, sex. And then we had another one that we need to talk about here. Now we're going to get kind of interactive, and I may pull some of you into my world and have you make some arguments here, but we need to do it in a way where Ann can pick up a lot of what we're doing here on the audio and the video. So I'm going to be asking you a lot of questions to kind of bring out some of the fair housing material we're going to cover. Can you require your applicants to have a Social Security number? Who says yes? Who says no? You think no over here, guys? Okay. Gentleman in the plaid shirt. Why are you so You were immediate yes. Why do you think you can say yes to that? Or why do you think you can require a Social Security number? If you're doing any kind of a background check, who does background checks? Good. Background checks are good. Why do you do a background check? Help me out. So you don't end up with somebody with felonies in your building. Yeah, a client called me on the way up here, said, I just found out my tenant's running a chop shop in the house that I rent. What's a chop shop? That's kind of an older term. Yeah, taking cars apart, selling them, major felony kind of stuff. And I said, well, Gary, did you run a background check? He said, interestingly enough, I did. I think it's her boyfriend. So yeah, you guys have who has rental criteria that you have to meet for your owners? Okay? Who just owns your own property and manage it? Do you guys run background checks, obviously, because you want to get a certain caliber of people in? So this question, what protected class might that bring up? This is a very current issue in our country. Excellent, another bullseye. Somebody who is maybe got a green card, working here legally, but maybe somebody who isn't here legally. So what protected class does that bring up? Very good. National origin. You guys, I thought you looked like a sharp crew. You are a sharp crew. Good answer. National origin is where somebody is from. And little like HUD and CCRD and other civil rights agencies around the country view that a little differently than race. The term Hispanic would fall under this, but it's not the only one, where it's where somebody hails from. And somebody could be in a protected class because of their race. Like when I see civil rights complaints come in, they have little boxes that the organization will check as to what somebody's protected class is. Sometimes you might see 2 boxes checked, Mexican American and national origin, Hispanic. But we don't have to get hung up on semantics. It's just enough to know that national origin is a protected class. So go back to this slide with me. And so how does national origin factor in? Great job bringing that up, but how does it factor into this question? People from other countries that you might be looking at don't have Social Security numbers. Exactly. So here's the real question behind this. Can you deny somebody a rental who is not a citizen or here legally? What's the answer to that from a fair housing standpoint? Can you deny an applicant who is not here legally as a resident alien or who is not a U.S. citizen?
Is there a way to do a background check without having Social Security number?
Ooh, and that's what's really, there's 2 things behind this slide kind of hiding back there. My question and this question, do you really need a social to run a background check? And I'll get back to that in a second. What do you guys think? Do you think you have to have a social? Legal name, date of birth. Now, some of you that do some multifamily stuff, do you use a vendor, a company to run your background checks? Who do you guys use? Kroll? Oh, wow. Kroll is a company that I actually use for what they call like forensic data. They have experts that get into computers. I didn't know they did background checks, but it makes perfect sense. So Kroll, anybody use Credit Retriever? Well, these companies do these background checks, and they can do them now without Social Security numbers. Many people who are here with proper visas and have a right to be here, do they have socials right now? Correct. A lot of them do not. But they have EINs. They have tax identification numbers. So you run your applicant, and what was your question? They give you the wrong social?
Well, you don't have a social.
Oh. You don't have a social.
So,
All right, so here's the question. You get Johnny Jones trying to rent from you. Pretty common name, right? Johnny Jones. Doesn't have a goofball name like Wollenweber. And so you go to run him without a social, and you get all this bad stuff back on Johnny Jones, but it's Johnny Jones in a completely different part of Colorado. It's not your guy. Do you have an issue? Absolutely you have an issue, but I bet you have a thought on that.
Well, that's where the date of birth comes in handy.
Date of birth comes in. So if you run Johnny Jones with the date of birth and you get something that doesn't meet your rental criteria, The question is, could you have the wrong Johnny Jones? Maybe. But is that going to be something you're probably going to get stuck with? Probably not. It's a real interesting question, though, because we're asking, do you have to have a Social Security number? So let's go back to my two questions, and I'll tie it back to your issue there. So one, national origin, this raises the issue. Can you say no to somebody who's not here lawfully from a fair housing standpoint? The answer is yes, you can. You can. You can absolutely, there's going to be a gigantic but. Lawyers love it depends and but. The answer is yes, you can definitely deny somebody who's not a citizen or here with legal right to be here under those standards, but, and that's not a fair housing violation, but you better be real consistent. You better be real consistent. Let's say you manage 4 different single-family homes, and at your properties in Fort Collins, you're real strict about it because your owner's like, hey, I don't want any illegal aliens, and you deny them. But at your properties, maybe over in Loveland, you do something different, and you let in folks that don't have a valid right. You're starting to really maybe expose yourself to some fair housing discrimination. In other words, if I'm from the Middle East, am I protected under national origin? Absolutely. And if you don't rent to me because I don't have a lawful right to be here at your apartment community, and then I find out that you rented to Mr. Sanchez, who's just as unauthorized to be here as I am, then suddenly it's fair housing discrimination. We're in different protected classes, and you're treating me differently. We're going to talk about what discrimination is, and this is a great time to do it. What is discrimination? We've all heard the word a ton of times in our life. What does it mean? Anybody, help me out with that. Deny somebody something based on their protected class. Both great answers. Denying somebody something, a term, condition, or privilege of housing because they're in a protected class, or treating somebody differently. If you treat one person in one protected class differently than somebody in another, and it's not comparing Caucasians to other protected classes, it could be you treat an Asian American better than you treat a Hispanic person or somebody from the Middle East. You have committed discrimination, even if it wasn't absolutely your intent. If it looks like it's your intent, it's discrimination. We're going to talk about that. So, no discrimination if you deny people because they don't have a valid reason, but you better be consistent. And then no, you don't have to require social, because I think there's so many ways now. To answer your concern, if you use a really good vendor, they're going to get other criteria that really make sure you're searching on the right guy. And there are a lot of people here legally that do not have Social Security numbers. And I think if you require it, it's what we call in law kind of a slippery slope. You could kind of be bordering on maybe a national origin issue. What if you have a Middle East resident that's only been at your property a little while and says to a buddy in the management office or out in the common areas, man, I can't wait till my home company, Iraq, gets better nukes so we can bomb the United States. What are you going to do? Come on, knee-jerk reactions here. What are you going to do? Call who? Call Homeland Security, see if he's on the major watch lists. Call the FBI. Yeah. But are you going to evict him over that comment? National origin is at issue here. It's a tough one. These are all things that these situations today aren't things that I made up or somebody at my law firm made up one night after a couple sips of Jack. These are real-life situations that we deal with all the time. And this came up one day. A gal called, said, you know, Muhammad Amidi, one of my tenants, just made this comment to me. What were you going to say about it? Well, if you're the potential victim of his comment and you're Caucasian, would you be discriminated against? That's an interesting way of looking at it. I never thought about it that way. But let's just break that down real quick. Is Muhammad in a protected class? Yes. Has he said something that is alarming? Heck yes. But has he stated he's going to do it? Is it more like an opinion? Yeah, and he might feel like you're profiling him if you take the next step. Reason we always bring that one up in these classes is you kind of got to think about these things in rentals as, all right, if we're going to take some type of adverse housing action, eviction notice or a warning letter, something like that, we got to make sure we have really solid reasons, and we're going to talk about that today. All right, okay, summer's a-coming. And who comes out of the woodwork in the summer all over the town? The kids. I was interviewing Brianna with an association yesterday, high-end, and they were showing me a bill for graffiti cleanup. And I'm like, graffiti? Yeah, you guys got like $700,000 homes. How do you have all this graffiti? She said the kids are bored. So I think kids can raise interesting issues for community. So, all right, it's summer vacation, May. Man, this one couldn't be more timely. And you got children out and about in the communities, and they're causing some problems. Neighbors have been calling constantly to complain. Well, who here is a property manager? Raise your hand. Anybody else, property manager? What's your first name? Vanessa. Hi, Vanessa. So let's say this is your boss, Vanessa, and your Vanessa's boss, Mary, just pulled into town. She's like, hey, Vanessa, I got a solution for all your problems with kids running around the community. It's time to lay down the law. I just drafted this rule, and it says, and we're going to post it to all your residents today that says, hey, all children under the age of 14 must be supervised at every single second, at all times in the community. That'll solve your problem. Vanessa says to her boss, Vanessa says, hey, that sounds pretty good, Mary, but that kind of sounds like what kind of discrimination? Very good. Familial status, which we'll cover here. So you've already seen that we're pretty serious about our graphics on our slides. Our jobs are just so serious we feel like the graphics need to be kind of low-key. Well, there's your thugs. They're out and about. And we've got problems. Well, can't we regulate that, folks? Can't we do something about it? Mary's saying to Vanessa, let's have a rule. But Vanessa's saying, well, but we've got a protected class here at issue. Who's the protected class that she's worried about? Children. Okay, are children in a protected class? Well, let's look at what familial status means. That was added in 1988. Means anybody under the age of 18 who lives with a parent, a legal custodian, somebody who they're there under the permission of a legal custodian, somebody who has custody of that person under 18, and look at this last one. Pregnant women fall under familial status. Why would that be? Because they're about to have somebody under 18 living with them outside the womb, right? All right, so it only makes sense. So that's the definition. So kids absolutely fall under this. So going back to that scenario, I think Vanessa's really onto something here. Why might passing a rule like this be familial status discrimination? Why? Help me out. Because it only affects them. It's a very good answer. It only affects the children. Hey, you have to supervise your kids at all times, etc., etc. All right, I'll come back to that in a second. But what if there's a pool at Vanessa's community? Can you have a pool rule about kids being supervised at the pool? My son Lance is out there at 8, and I don't want to dog my son too much, but he's a little behind the curve on swimming. Who has kids? Your kids learn to swim by 8? Yeah, he needs to get with the program. I don't think I'd want Lance out there without Susan or me supervising him. Can you have a rule for supervision at the pool? Yeah, absolutely. Why would that be okay? Health and safety. But hey, these kids aren't being safe. They could hurt themselves. They could hurt the community. What's wrong with that? So we got to distinguish these two things here for a second. So you got these kids that have to be supervised all the time. Well, I think what Vanessa's getting at is right on the money. We're putting out this blanket rule that they got to be supervised at all times. And what does that look like? The Fair Housing Act says it's discrimination to have a preference for or against treating people differently or denying somebody something. A protected class, a preference against or for. And I'll tell you right now, CCRD and HUD would say to us, if they were in the room today, having a policy like that is familial status discrimination because it's all across the board. But if you had a rule everybody, kids must be supervised at the pool who are 14 and under, they wouldn't have a problem with that. Why that distinction? Here, the presumption is all kids are going to be a problem. And in this modern day and age, can parents, who manages an apartment community? You guys do. Okay, housing authority of multifamily properties. Do kids live there? Lots of them, right? What do you think of a rule like this? Sound good to you? No, he's shaking his head. Don't have kids sounds pretty good to me, but your colleague behind you is saying, I don't think it's such a good idea. You know, because it's targeting them all across the board with no really explanation why. I'll come back to the pool in just a second. I got a crazy case right now I'll just share with you guys. A gal moves in to the community not far from here, and she filed a CCRD civil rights complaint. So we're going to talk a little bit about that today. When somebody feels they've been discriminated against, they can go down to HUD or CCRD and make an allegation in a written complaint that the landlord or somebody else is discriminated against them. And in October, this gal was living at one of my clients' properties in Colorado Springs, and she brought a CCRD complaint saying, hey, the community is discriminating against my disability because they won't get a handle on the kids. The kids are really loud, and it exacerbates my disability. Okay, that was the complaint in October. I start dealing with her. We come to an agreement, and we settle with her, and she moves out. She drops her complaint. And Wes never heard from her again, right? Wrong. Right. Good response. Nope. March rolls around. I get a call. Did anybody come to the class today from Countryside Asset Management? I think so. That's the client that's now dealing with this gal, and they have properties up here. So Ginny and I were kind of wondering if some of them might come. So then I get a new CCRD complaint from a new client in North Glen, Colorado, actually further north than that. And she'd moved from Colorado Springs all the way north and made the same exact allegation against a whole new landlord. Okay? Now, she would love a rule like this. Make sure the kids are supervised at all times. If she sees one kid out and about, she drafts a written complaint. But what is that causing our client to have to maybe do? I think discriminate against kids. What's the reality? Can parents in an apartment community supervise their kids at all times? Housing authority? Why not? I don't know if there's laws out there about the age when somebody can be alone. I'll have to look into that. Is there? That's right. Yeah, I was looking into that the other day because Susan and I were like, gosh, can we go for like a 5-mile bike ride and leave Lance alone? What's the law? And she said, I heard it's reasonable. And like, that's a little scary. Somebody asked me the other day in fair housing, what does reasonable mean? And I couldn't give a very good answer. I think it was actually in a class that Brianna and I were in for HOAs when we did you stay and do the assistance animal class, the advanced fair housing class? Somebody's like, well, how do you define reasonable? And nobody liked my answer. Whatever's reasonable to the average person. So I don't know, what the law is on that other than what a judge, a law enforcement officer, or somebody maybe from social services says it is. But what I do know is that in most communities, it's completely unrealistic that parents can be there all the time. What is realistic to me, and what we said in response to all these allegations to the CCRD is, our policy is parents cannot leave their kids unsupervised for lengthy periods. Let them cause danger, let them cause excessive noise. This gal has made 28 complaints in 45 days. Many of the complaints have multiple things in them about multiple units. Kids on their scooter screaming. Yet she's never told us what her disability is exactly and why it bothers her. So anyway, we have to try to defend that one, saying that we might be discriminating kids if we did everything she wants us to do. She called social services on a neighbor she's not getting along with, and social services said to this other resident, you have to supervise your kid at all times. And I just couldn't believe it. I think this is pretty discriminatory, but let's distinguish this from the pool. Okay, so pool, I said it's okay to have like maybe a 14 and under rule, like parents, you have to supervise your kids 14 under. Why would that be okay, different than this? Okay, because it's life-threatening. I think there's 3 answers to this question. That's the first one, another bullseye. You're dealing with a specific risk of harm at the pool, life-threatening. 2, it's not just this blanket policy. It's saying kids under a certain age need to be supervised at the pool, not everywhere. And 3rd, why would we have that age? Where would that maybe come from? Who's been to a public pool in the last couple of years? I have. Anybody else? They always have those rules. Well, where do they get them? Well, I looked into it one time. Nancy Snow told me they get them from the Red Cross, 14 and under, because they've just done studies that kids under that age need some supervision. So the way discrimination kind of works, and I think this will kind of help you distinguish these 2 things, is if I feel I'm the parent of some kids and you went ahead and you did, Vanessa, what your boss said, and I get this letter, and I march in, and I said, look, my kids play outside from 5 to 6 every night till I get home from work, and they don't bother anybody, Vanessa, and I'm really mad about this. You're singling out kids. If I go down to CCRD and file a complaint, the investigator's going to take a look at this thing, and I have to prove that you've treated my kids differently than somebody else in a protected class. The way discrimination works is then you, as the landlord, I name you, I name Mary, your boss, and I name your company in this complaint. You guys have to show you have a legitimate, non-discriminatory reason for taking this policy. Okay, legitimate, non-discriminatory reason. Are you going to be able to show you got a non-discriminatory reason? You could try and say, well, we got kids all over. But CCRD may look at it a little differently. I got to pick on somebody today. It's going to be my civil rights investigator. Who works with somebody next to you here? Nobody? You're all from different communities? Oh, shoot, that's not going to work then. Who knows the person next to you? Okay, good. I'll go to the ladies in the front. Who's the more argumentative out of the 2 of you? Flip a coin? You can rat each other out. It's a toss-up?
I'll take the fall.
All right. All right, what's your first name?
Dion.
That's Dion. All right, so I'm going to use Dion a little bit. Dion's going to make some arguments for us here. All right, so I come down. You're a civil rights investigator hired by the state, so low pay, cruddy benefits, and you got to investigate all these civil rights complaints. How's this one sounding to you? Vanessa's company says, hey, our legitimate non-discriminatory reason is we have kids running loose all over the place. We got to get a handle on it. What's your comeback to that? I'm saying it's discriminatory. Okay, kids are protected class. Very good. You want to join her?
Right. Are they causing problems? Is there anything specific? Is there damage done anywhere? Is there...
Vanessa?
Loud.
Excessive noise.
And I would say every single child that lives there, can you prove that every single child there? That's the thing. It's not.
All right, I like where we're going with this. So Vanessa's company says in response to the allegations, we have kids running amok. Look at Brutus fighting. We got the Fort Collins rolling Crips there, beating up on each other. We've got trikes left out, excessive noise. We got all kinds of reasons for this policy, to which Dion, right, says, say it again, that was beautiful.
You can prove that every single child under the age of 14 is a problem.
Can you prove every single child under the age of 14 is a problem? Speaking of kids, the fist pump. Nice job. That's exactly. This is why I like to do this. Civil rights investigators, you know what they use? Common sense. They think like all of us do. Beautiful answer. She says, do all your kids under 14 have these issues? Because that's what your policy is saying. Do all kids under 14 kind of need to be supervised at the pool? According to Red Cross, yeah. If you have a rec room with exercise equipment, maybe you have a rule based on what the manufacturer says. And that would apply to all kids, kind of uniform. But here, you hit the nail on the head. And what CCRD would also say is, you have a lease. You have language in the lease about disturbing others. Figure out who the violators are. Now, that's hard. You may not know whose kid this is that's out throwing tennis balls at cars, breaking windows with rocks. But you got to kind of try to find out, because that is a blanket policy. Good job. So that's some of the stuff we're going to do. All right, Applegate Apartments, beautiful Fort Collins property, and they have no reserved parking. Who's got parking lots at your communities? Housing Authority does. Brianna does. Brianna, you have, what, 8-plex, 14-plex? Okay, 14-plex. The HOAs are condos. They have parking lots. The 14-plex has some parking. Do you guys have reserved parking for, okay? Many communities do, though. They have these reserved spaces saying, all right, Mario in Unit 201, here's your parking space. Mary in 305, here's yours. So one day, Ronnie resident comes into the office and he asks for a reserved parking place. What do you say to him? Housing Authority people, help me out. You said, hey, we deal with some folks with disability issues. He says he needs a reserved space. Do you have to give him one? What's your inclination? What's your gut? Don't think so? You're saying, who said yes? You said yes? Who says, I have no clue? If he has a mobility impairment, okay, but look at that sign. Out in the lot is this really cool spot with the handicap designation on it. Why can't Ronnie park there? What's your first name? John. John had a good answer there. Another bullseye. He says, well, Ronnie, if he has a mobility impairment, he may not have access to it. There may be a lot of people that park there. Outstanding. I'm going to come back to this in just a second because we are now moving in to another protected class, which is disability. Very good. And it is a big one. The reason it's a big one, if you were to ever come to one of my more advanced classes, Brianna attended a homeowner association class at a trade show, and the entire material we covered was all related to disability. Reason being is out of all the civil rights complaints filed with HUD nationwide, about half relate to disability issues. My firm, out of all the calls, and we have hundreds, thousands of clients just like you guys, property managers, owners, housing authorities, communities that run mod rehab projects, senior facilities, assisted living facilities. Out of all the fair housing calls I take, and I just take a SCAD, I would say 99% of them seriously deal with disability issues. I rarely get an issue that's over family, kids. Once in a while, a different protected class, but this is the big one we got to spend a little bit of time on. All right. So if he's mobility impaired, which might be obvious, like he's in a wheelchair, John's saying, yep, you might have to do this. All right, we'll come back to that in a second. Rita, resident, physically disabled, obviously, uses a walker to get around. You've known her for years. Very nice lady, except those days where she gets a little testy with her walker. And she asks you guys to install grab bars in her shower to help balance herself. Who's heard of grab bars? A lot of you have. Okay, way over there, gentleman in the ball cap. What's a grab bar? Okay, excellent answer. A grab bar might be something you find in her, might have to put in her bathtub or somewhere in the bathroom to help her balance herself. Okay, show of hands. Let's go to the housing authority people. John and your colleagues. Again, I'm sorry to pick on you, but I know you guys see these type of issues come up. Do you have to grant her request to put in the grab bars? What do you think? Yes? Okay. If you have to put in the grab bars, who pays for them? What do you guys think? John says he thinks his outfit, his housing authority would have to pay for them. Who else thinks you'd have to install Rita's grab bars? You guys do? Let's see how my short-term memory is. It Mary? Donna and Dion. That's going to be a little easier for me. Oh, sorry, Donna. Donna said, well, I think we install them, and we would have to do that, but I don't think we have to pay for them as the management company or landlord, that Rita would have to pay for it. Who thinks that's the right answer? All right. We're kind of merging into the new area here with disability. We'll come back to these slides, and I will answer these questions with you guys. But it brings up disability. All right, so first, we're going to deal with some slides on disability. We better start with understanding who falls in this protected class. We said in 1988, Congress added this to the law. Started out with the word handicap, and in the federal law still does say handicap. But over most of the states that have their own fair housing laws, they use the word disability, and even HUD, when they lecture on this, they kind of use the word disability. Just know it's the same as handicap. This is the more common nomenclature. But let's see who falls in this protected class. Somebody with a physical or mental impairment that substantially limits one or more major life activities, a record of a disability, or somebody who's regarded as being disabled. I'm going to start with this third one. I don't think we need to talk about it too much. It means if somebody really isn't disabled, as defined up here, but people think he or she might be. In other words, they're perceived. That comes up a lot more in employment law than it really does in housing. So let's back up here for a second. This is the big one. For somebody to be disabled, they need to have a physical or mental impairment. Okay, I think we all know what an impairment is, that substantially limits one or more major life activities. What are major life activities? This should be something, just knee-jerk reaction. Walking, driving, that's a good one. Standing, keep going. Sitting. Self-sufficient is an interesting one, caring for yourself. What are we all doing? Vision, seeing, good one. What are we all doing right now, even though we're having just a ball in this class? Listening, and we're working, right? Technically, we're all at work. Me, it doesn't feel like it because you guys are a lot of fun, and as I was telling Jenny, these classes are a real escape for me from my conflict world, but we're working. Well, who do you think came up? That's a definite major life activity. It's the things that we all do on a pretty much a daily basis, but who do you think came up with this definition? An MD? Psychiatrist? A lawyer? Terms, conditions, privileges, substantially limits. A pretty good guess. You're getting real close. Interestingly, your Supreme Court did. And then it got put into all the laws. And I never asked you this trivia question. All that 60s legislation, who do you think, which political party was actually behind getting it implemented? Democrats or Republicans? Democrats, pretty good guess. Who says Republicans, though, ironically? Oh, you'd be right. Yeah, Republicans passed all that through. I think MLK was Republican. I think it was because at the time, people like Al Gore's father, William Fulbright, who was Clinton's mentor, they were Southern Democrats with the heritage of having plantations, and they were kind of against that legislation. And it was definitely Republicans in Colorado that passed the first Fair Housing Act. So I thought that was interesting. One thing, even though I wasn't a huge fan, that George W. did before he left office, it was big. He signed a bill under the ADA, which is the Americans with Disabilities Act. We looked at that slide. The ADA covers employment, and it only applies to you guys as owners and property managers to places that are places of public accommodation at your community. And that's very few things. Who here has a leasing office where your property is? Anybody? Like large apartment complexes have a leasing office. That's open to the public. Anybody can come in. Clubhouse, is that open to the public? Is a clubhouse public accommodation? The reason the ADA is important is because it requires some things like the fair housing accessibility laws. You have to have certain kinds of parking, bathrooms. Clubhouse, only a public accommodation if you rent it out. HOAs, only their pool, only public accommodation if they rent it out. If it's a guest or if resident or a resident's guest that uses it, it is not a place of public accommodation. So ADA doesn't come up much, but it has the same definition. And the problem in employment law was our judges kept playing with this, saying that people don't fit the definition, that you got to be like severely disabled to meet this definition. Like I walked into federal court, a judge I really liked with a client years ago who had pretty severe fibromyalgia. That wasn't her main issue in her case. She had been fired because she went to the labor board on a labor issue, and they fired her about an hour after she made the complaint. But she also said, hey, they're discriminating against me because I have a disability. I have really severe fibromyalgia, and they won't take me out from under this really cold air vent. Anybody heard of fibromyalgia? You see that they got commercials now for it. You know, a rheumatological condition. Her evidence was, hey, I only get 2 to 3 hours of sleep a night. That the condition wakes me up and I really suffer. And the judge says to my client, well, ma'am, you know, and a judge I really like, old cowboy judge from the southeast part of the state, who I think's brilliant. He said, you know, I'm sorry, but you don't have a major limitation to a major life activity. Sleep is a major life activity, but guess what? As a federal judge, guess how much sleep I get, ma'am? 3 to 4 hours of sleep a night. So he didn't feel she met that definition. But Bush, before he left, signed a bill that says now how the courts must interpret this, and they must interpret it very broadly. So let's figure out who falls in here. It could be physical, notice this, or mental. And it must substantially limit. What does that mean? It means that it's going to be a condition that medical people don't think is likely to ever improve. Let's say I broke my leg really bad out at Steamboat Springs, and I come in a big cast, and I say, Brianna, man, you got to transfer me to a garden-level unit at your 14-plex because I can't negotiate the stairs. Am I disabled? No, probably not, because my doctor's likely to say once that leg heals, I'll probably walk just like anybody else who's not physically disabled with their leg. But what if, like my mother-in-law who broke her leg so bad one time, whoops, I did it, sorry, that the doctor said you'll never walk right again. You know, she broke it in like 36 places. And I have a cast, and I have medical documentation that says that. Do I meet this definition? Yep, I'm substantially limited. So the definition of substantially is whether it's really going to impact somebody through their life or it's unknown whether it will. If it's really a long-term thing and it affects a major life activity, it is a disability. My wife came to one of my classes. She said, is shopping a major life activity? I said, no, sweetheart. I think it has to be the things we do every day. But who decides what's a major life activity? The courts. How do you like them apples? Or it could be a record of a disability. What does that mean? Somebody that has a true record of a disability. John, can you think of something there? What do you guys see sometimes from the folks you provide housing to that might be a record of a disability?
Well, I mean, if someone's getting like SSI, or they're considered disabled.
Social Security Disability Income, SSDI. That's a record of a disability because to get it, you have to prove that you have a major limitation. You can't work, and work is a major life activity. So if somebody has SSDI, they definitely have a disability. So back to the gal who can't stand kids, she gets SSDI. Is she disabled? Yes. But she said that these kids were really bothering her disability. And did she ever tell us how or what her disability is? No, she didn't. All right, at the break, great question. I kind of blew through that Americans with Disability Act issue. So let me go back to that just for a second. Many people confuse the Fair Housing Act with the ADA. Who's heard of the ADA and thought it was fair housing? Some do. All I was saying is that the ADA will only apply to you in housing if you've got a place of public accommodation. So the ADA applies to places that are open to the public in employment, education, and housing. If the city of Fort Collins owns rentals, ADA applies. The only major difference with the ADA and fair housing is ADA has some very specific mobility impaired requirements, parking requirements, but when you're out at DIA and you see the person with the service dog, that's an ADA issue, not a Fair Housing Act issue. So all I was saying is the ADA would rarely apply to anybody here in the room unless somehow a part of your community property is open to the entire public. If I manage Happy Acres apartment complex and we've got a leasing office, anybody can come in to ask me to rent an apartment. That's open to the public. But over at the pool, no, not everybody can use the pool. Who can use the pool, Dion? Tenants and their guests, yeah. So that was a great question, and I wanted to clarify that. All right, so is somebody who's alcoholic disabled? Well, let's see here. All right, what can people with disabilities request? What can they ask for? What did Ronnie ask for, John, when he said, give me a close-up reserved parking spot? Very good. A reasonable accommodation. Okay? What did Rita ask for when she said, hey, please give me grab bars? Very good. Somebody said modification. Okay, modifications and accommodations are something that under the Fair Housing Act, disabled individuals, people who meet that definition we just covered, are entitled to make requests for to help them with their disabilities. Okay? Now let's talk about what these two things have in common. So we had Rita. She needs grab bars. Why does she need grab bars? Mobility. Balance her out. Very good. Ronnie, resident, wants a close-up reserved spot. Let's take John's point of view and say, yes, he's in a wheelchair, has a wheelchair accessible car. He says, hey, I just can't fit in the regular spaces. I need a reserved space, and I need it to be closer to where I live. This even come up in an HOA recently. They had dedicated parking, and somebody wanted to move their space closer to where their unit actually was from where their garage was. Same type of deal, and it was because he was in a wheelchair. Would that be a modification or an accommodation? Well, let's look. What they both have in common is that it has to be something that helps a person who meets that definition of disability enjoy their community, live in their community the same way that a non-disabled person would, same way I would. So Rita is asking for something to not make her have more special rights, but to live in the same way that a non-disabled person would. Now, up to now, we've been talking about not discriminating, treating everybody equal. Now we're kind of going a slightly different direction here with disability. Why? What are these two folks asked for? They've asked you to do something a little out of the ordinary, right? Install grab bars that aren't already in the bathtub. And that could even happen at a single-family home. They could come to you with your single-family home and say, hey, I want, your lease says I can't, whose lease says I can't screw with your house, change it, modify it without your permission? Gary, you say that? So I come to Gary and I say, I really need these grab bars. Okay, so these are folks asking you to do something out of the ordinary. So that's a little bit of a switch in what we've been talking about in terms of equality. So they're saying, hey, need something so that we can live in our community the same way non-disabled people would. What's different about modifications and accommodations based on what we know from these two different requests? Modification, give me some grab bars. What's another type of modification somebody's asked for in your professional career? And some of you had to deal with something. A ramp. Excellent. A ramp. Person in a wheelchair needs access up some stairs or some other area that's blocking them. That's a hammer and nails modification kind of thing. Modification, structural, hammer and nails. The kind of things you wouldn't let me implement at your property if you were desperate. My wife doesn't let me touch any power tools in the garage because I'll destroy something. So in other words, your handyman, everyday contractor kind of stuff. Some are small ticket items like Rita's grab bar request, and some are big ticket items. Now accommodation is different. What it is a request for an exception. Did everybody hear that? An exception to a rule, policy, practice, or procedure. Man, that's a lot like terms, conditions, privileges. What's a rule, policy, practice, or procedure? Pretty much everything you guys do. Your lease is one big set of what? Rules. Most of them are rules. Landlord must do this, tenant must do this, tenant must not do this. The things you do as a matter of habit are practices. You have policies. And some of you offer certain services. Housing authority, do any of your communities allow pets? Yes? Do your maintenance people clean up after the pets? John's saying, no way. John, the communities that you know that have pets, do they not clean up after them? The resident has to. All right, so that would not be a service you provide. Good, that's going to come into play here. All right, so modifications, accommodations. disability. Let's go back. Rita, she's asked for. Okay. Now, if you're taking notes on your slides, go back to that slide, slide 31. I told you, you guys have rights as housing providers and managers. You have a right when you are faced with a disability request for an accommodation and or a modification to ask the following three things. One, whether the person requesting it, Rita here, has a disability. That's one. Whether they have a disability, he or she has a disability, as defined by that slide that we went over, physical or mental impairment that substantially limits a major life activity. Poor Brianna, she's got this down pat because she's been in 2 fair housing classes I've done in less than a month, which is very unusual. Second thing you have a right to know is whether they need the modification or accommodation. Whether they truly need this. Because we said in that slide a little bit ago, it has to be something that helps the disabled person have equal use and enjoyment of the unit, the community, even the common areas at an apartment complex or a senior community, the same way a non-disabled person would enjoy the unit, the common areas, the community. All right, so need, if you're taking notes, means there has to be a definite relationship between the disability and what the person's asking for. If I say to you guys, hey, obviously I'm in a wheelchair, I'm disabled, and I happen to be a trust fund kid, I've got a lot of dough. This could go at a house or an apartment community. I say to Brianna at her 14-plex, hey, I want to put a gigantic basketball court in the back and have my wheelchair basketball crush league out there, and I'll pay for it. Am I disabled? Yes. Do I need? And Brianna's like, heck no. No, that's more of a, as we say to our kids, that's a want, not a need, Wes. So no, that I have no relationship between my disability and definitely needing it. It'd be great, but I don't need it. And the third thing you're entitled to know, there's this word, whether it's reasonable. But I do have a definition now for reasonable. The federal government relies on federal regulations under the Fair Housing Act to interpret the act, and the regulations say reasonable is if it's feasible or practical. Okay. So, Rita, we want to ask if she's disabled, does she need it, is it reasonable? And then I'll give you some guidance on how we really look at those things. Is Rita disabled? Physical or mental impairment that substantially limits a major life activity. Is she disabled? Absolutely. Does she need the grab bars? Pretty obvious that she does. She needs them to balance. Okay? Good. Is it feasible or practical, reasonable to put in those grab bars? Okay? Great. But we also asked you a question then. All right, so there's 2 questions. Do you have to grant the modification request? And who has to pay for it? And we had some different answers on who would have to pay for it. And then we'll go to Ronnie here in just a second. So let's stick with the modification. Are we going to grant it? Okay, if somebody denies it, Dion, you're the civil rights investigator, they say, well, she didn't come to us with any kind of documentation that she's disabled. And Dion, I've seen Rita walk to her car 90% of the time. So we're not giving her a modification. How do you respond? Discrimination, denial of a reasonable modification. Ooh, I like that. Did we ask her for proof? All right, I'll come back to that. CCRD's thinking about it. Who wants to be the landlord's attorney? Somebody in here who's good arguer also. You're always at home taking out the rest of your family with solid arguments. You again? Donna?
I don't know.
Big L.
If someone asks,
Small investment, put it in. The big L. Liability. I like that. I'm going to start using that now. I've never heard that. The big L. Brianna and I were at a trade show where we were putting on this education, and so you're always handing out stuff. And I used to hand out this flyer that says, what you don't know will hurt you, to get people to come to my fair housing classes. Now I'm just going to call it the big L. I love that. It is a liability issue, absolutely. And speaking of that, here's the key to these modification accommodation requests. Gary heard me say this at the 1-hour summary class. I'll kind of date myself here, but who remembered the days of Nancy Reagan? She had the war on drugs slogan, just say no. Pretty good slogan on drugs. Maybe even on, well, I won't say on medical marijuana, which there is an article in your materials about that. And I may comment on medical marijuana before over, but Nancy said just say no. Do not follow that policy with modification accommodation requests. Right, Housing Authority? Because that will get you a big L stamped on your back. It is absolute per se discrimination to just say no right out of the gate. And I'll tell you about that here in just a second. You want to go through a dialogue with Rita, with Ronnie, with those 3 questions. Are they disabled? Do they need it? And is it reasonable? Now, in our advanced classes, we spend a bunch of time on that. I'm just trying to give you the real solid basics and so you know what your rights are. Because there are people who make requests and they're not disabled. So we know she's disabled. Who's going to pay for it? Raise your hand if you say Rita. John, you're going to say, we are. Interesting. If you're taking notes, here's what the answer is. It depends. It depends on which law governs the modification. Everybody in this room, who's responsible for fair housing in this room? Raise your hand if you think you are. Got somebody over there that says, no, not me. I think maybe everybody. Depends if you maybe you don't own or really deal with housing. But yeah, most of you have to comply with fair housing laws. So, the Fair Housing Act applies. But if you get federal money in the rental process, as the housing authorities do, they manage Section 8 properties. Sometimes they have tax credit properties, which is an IRS mechanism, but they may get federal money. Then Section 504 of the Rehabilitation Act, which we had a slide on, applies. So let's go to John's property. What's one of your communities, John, where Rita might live? Okay, Village on Stanford. Gets federal money? Yes. So what law is going to apply if Rita makes this request? Let's say it's a ramp. I got some bad news for you. The grab bar's only a couple bucks, and this gentleman would be happy to come over and do it for Rita. But she also needs a ramp. You've got a bad spot in the parking lot. She's not getting in and out the days that she uses her scooter. And she needs the scooter. Big ticket item. Well, under 504 of the Rehab Act, which is also a type of fair housing law, it says the housing provider has to pay for the modification. So the housing authority has to come up with that money for the ramp unless it would pose a major financial obligation or burden, on their budget. What about the Fair Housing Act? Who pays for the modification? Good news is you can condition the resident on paying for it. That's important with a big ticket item like a ramp. But as Donna said, hey, something small like grab bars, we're going to do it. Why would you pay for something maybe that's not as expensive for a disabled person? Goodwill, goodness of your heart. But one little tip from Wes, make sure if you do that, you kind of have a set policy about the dollar amount. Like modifications up to a couple $100 or whatever it is so that you're treating people consistently. All right, so Rita, good job, guys. We're going to grant her the modification. What about Ronnie? He says, I need this parking place. Let's say Ronnie does not have a mobility impairment that we know about, John, and he makes this request. Okay, so what is this a request for? Modification? Very good. No, it's an accommodation because he's asking you to make an exception for your policy that it's reserved only. All right, so let's see if you've been listening to me. What's the first thing you have a right to ask Ronnie? Outstanding. Is he disabled? What's the second thing you can ask? Does he need it? Very good. And what's the third thing you can ask? Is it reasonable? All right, good. Well, we're not done with Ronnie just yet. Remember what I said about Rita. Where reasonable, you can condition you granting a modification on her paying for it. And if it's a big ticket item, you could even ask her to put it back. That's a pretty complicated issue. Understand modifications can be interior or exterior. All right, back to accommodations, exceptions to rules, policies, practices, services when they're necessary. Now look at this. One thing to know, accommodation, if there's any money involved, unlike what we just said about modification, the landlord has to bear some of the reasonable costs. Most accommodations don't really cost any money, but Ronnie asked for a reserved spot. Now, accommodation, yeah, it's an exception to a policy. You could maybe argue it's a modification because you got to put in maybe some striping, maybe a sign. But I will just tell you, HUD, CCRD, and the United States Department of Justice, who I'm going to comment on just who the heck they are in the world of fair housing in just a second, they view a parking request as an accommodation, that you're making an exception to your normal parking rules. So you might have to bear some reasonable costs. Had one time at a community where a gal said, I'm deaf, and I need a deaf interpreter. Just so you don't think I'm using the wrong words, I've learned that it's either deaf or hearing impaired, depending on the degree. She was deaf, wanted a sign interpreter at certain events that the management company oversaw, picnics out at the apartment community, stuff like that. And she said, that is something you need to provide me because I'm disabled. And if we granted it, there's costs involved. That gets pretty expensive when you rent those folks for a whole day or even by the hour. But we kind of gave in on it, but our argument was really going to be, hey, that's not a service we really offer. We don't provide interpreters for folks who are Spanish only or anybody else. All right, but you might have to bear out the cost, but again, not if it poses a major administrative burden or alters the nature of the services. Another tough case I handled. Gal has multiple chemical sensitivity disorder. Anybody ever heard of that? You have, Dion? I'm not sure exactly what it means, but I think it means you're allergic to planet Earth, like everything. And so we kind of basically, we ended up calling her the bubble lady, not to be mean, but we sealed her entire unit, all the vents. But every time they do routine maintenance, here's her accommodation request. I want to go to a bed and breakfast. And not just any old bed and breakfast. I want to go to this one that's vegan and is smoke-free. Our client says, okay, it's an accommodation request, but that fundamentally alters the nature of our services. They already house people. They don't provide alternative housing. Very controversial issue. HUD eventually, that one went all the way out to DC, and HUD said there's no way to accommodate this person as far as her sensitivities. Unfortunately, that particular client has done other things to her now that has raised a host of issues, and I wouldn't represent them on it because I thought they were going down the wrong road. But I certainly understood where they were at there. Okay, now, real quick, United States Department of Justice, they're over the FBI, they're over the U.S. Attorney's Office. They also enforced the Fair Housing Act along with HUD. And they published, along with HUD, something called Reasonable Accommodation Modification Guidelines. And that's something I teach in my advanced class, but I'll give you a couple tidbits. They really want you to follow these when you deal with an accommodation or modification. Here's one of the first rules from the guideline. In asking that first question, is Ronnie disabled? All right, so he asked for the parking place, but not mobility impaired. Do we know if he's disabled? Do we know if he needs the space? No, we have no idea. And remember the definition, a physical or, very good, mental impairment. So maybe Ronnie's saying, hey, I'm mentally impaired and I have a handicap placard. I have the handicap signage. And like John said, hey man, I can't park in that one handicap spot that's in building A because somebody's always taking it. Or maybe you manage an HOA unit for a condo owner and he says, I can't park in my dedicated spot and there's these guest spots. I'd like you to make it reserved much closer to my house. What's our first question? Is Ronnie, very good, is he disabled? 2. Great, does he need it? Do we know answers to either of those? Okay, here's what DOJ and HUD say. You can definitely request proof of a disability when it's not obvious. Was Rita's obvious? Yes, none of you fought me on that. And you can request proof when need is not obvious. Rita, are we going to ask her for proof of her disability and her need for grab bars? Nope, it's just real common sense kind of stuff. But are we allowed to with Ronnie? Absolutely, absolutely. And if you ever take one of our very advanced disability fair housing classes, you also learn that you need to get these requests documented very closely in writing. Okay, so let's say Ronnie comes to you after John says, hey, love to help you out, Ronnie, but I got to know a little bit more about your situation. And here's a form that we use at the Fort Collins Housing Authority. I'm assuming you guys have a form, John, that verifies disability. Very good. It'll have the definition probably right on it. We need you to fill it out. Ronnie comes back. A form says, yes, he's disabled and he needs the parking place because due to a mental disability, he sometimes gets very fatigued, can't remember where he's at, and if he has a closer spot, he'll get into the building quicker and easier. Is he disabled? Yeah, the form said he is. And does it show need? Yeah, but you could certainly ask for the proof. What do you guys think this is used the most for? What kind of an accommodation would trigger this the most often? What's a type of an accommodation, Gary, that you think a lot of people ask for these days? We kind of talked about it a little bit in that 1 hour segment. There you go. Animals, therapy animals. And I probably shouldn't open that Pandora's box because Brianna can tell you we tried to cover that with HOAs in an hour, and it was real hard, wasn't it? There's a lot to know about what I call assistance animals. But people can ask accommodations for animals. And you're usually, especially if it's a therapy animal, you're going to be asking these questions. But if we want to go into that, or medical marijuana, we need to order some pizzas and a lot of beer and plan on being here till 10. So those are complicated issues. Here's the lowdown on animals. If somebody needs an animal, government, CCRD, HUD, DOJ, Justice, they look at two kinds of assistance animals. Service animals, which are what you would think a service animal is, a dog or an animal that performs a very specific function. And companion animals, dogs that provide emotional support, other animals, if you've seen Shetland ponies that provide support. Believe it or not, HUD does not differentiate between service and companion animals. They are considered two different species, if you will, of assistance animals. What you have a right is to know whether somebody's truly disabled, whether they truly need the animal, and whether it's reasonable. And reasonable is whether it's feasible or practical. And Denver does not allow pit bulls. I come to you and say, in Denver, my pit bull is my companion animal. It's kind of like the issue you brought up with the unrelated residents. Do you have to grant my accommodation request of a pit bull? No way. You do not have to violate an ordinance, like I said earlier, to deal with that. All right, so these are the things you can ask proof on. You're fine. Go right ahead. The resident? So a resident says, hey, single family home, I know your lease says no pets, but I have a service animal, Brutus. Brutus, seeing-eye dog, but there's no fence. You need to put in a fence. Asking for an accommodation or a modification? Great question. I love this question. Both. Make an exception to the rule and allow the dog, and a modification would be, in my opinion at least, a modification to the yard. Who would have to pay for the fence and put it in? I think the requesting resident. Touching my... Great question. So everybody clear on that? I think we have an accommodation and a modification, and unless you're under the 504 Rehab Act, you can make somebody pay for the modification. All right. Could you argue it's not reasonable, you could just put a dog on the chain, to which the disabled resident's going to say, kids are going to harass my dog. The dog's going to choke. The dog will hurt its neck, and I rely on him for vital help. One little thing on accommodations, you can always propose an alternative accommodation. Like, hey, no fence, but you can chain the dog up or do a little dog run. That's fine. But you cannot shove the alternative accommodation down the disabled person's throat or force them to take the alternative accommodation, why would that be? Because the disabled person, he or she knows what is best for his condition. So at the end of the day, if it's feasible or practical, maybe the HOA does not allow any, then the HOA's got to get involved and look at making an exception to a fence. And they're on the hook if they violate that. Yes, ma'am? Super question. Question is, you're not splitting hairs. That is a dynamite question and takes us in a little different realm. We've been talking about existing residents. What about applicants? I come in, you've never seen me. You're a no-pet community or a no-pet single-family home, and I say, hey, man, I got a great job, great FICO score, but I've got this companion animal, Shetland pony. You laugh, but I got an article the other day. Woman has a kangaroo as her companion animal. The kangaroo is disabled, and she cares for the disabled kangaroo. Luckily, it was an ADA issue, and DOJ basically said it was a viable animal that she can take into the airport or something like that. Anyway, I come to you, and I want my Shetland pony. And can't you just say to me, well, you're not a resident, and you need to look for a place that, allows pets? Outstanding question. Do you have to go through the 3-part inquiry that I just gave you with me as your applicant? Who says yes? Brianna says absolutely. John, immediate. You guys, immediate. Who says no? I should have just figured it out beforehand. Great question. Law says you have to deal with an accommodation modification at any point in your relationship with a prospect, current resident, or even after they move out. I've even seen accommodation requests, oh, don't try to collect on me for that lease balance. I had to break my lease because I had to move to an institution for my mental health, and you shouldn't hold me responsible. You may not have to grant a request, but you have to consider it at every juncture, especially with applicants. So there, you'd have a right to say, okay, well, I need to know if you're disabled. I need to know if you really need it. And I need to know if it's reasonable. You have to have that dialogue. You've got to go through that 3-part test. You don't want to just say no. Find a history of what? What if you do a background check and you find out that I've been a pretty bad resident at other places? Brutus has eaten the banister, bitten a neighbor. Where does that go? Disability, need, reasonableness? All right. Hang on to that for just a second. Let's go to this one, and then I'll answer that. Johnny Joe applies for a single-family home or apartment. He meets your rental criteria. Boom. He meets it. However, as you're taking him around, let's say you got a maintenance guy that works for you, and he's acting kind of weird when you're showing him the place. All right, he's just very menacing. God, I hope I don't have to sue you guys like my last landlords. And you're talking to your maintenance guy a little bit later, says, oh man, that last place I worked at before you guys, I saw this guy and he had a long history of hostile altercations with other people in the management. Do you have to rent to Johnny? Well, do we know if he's disabled? Yeah, maybe. Not if you feel threatened. Okay. You asked a great question at the break about alcohol, and we'll talk about that in just a second. It's all kind of part of the same thing. So we got Johnny Joe. Now, Johnny Joe, the definition, you got to figure out first, okay, is he in a protected class? So he discloses on his app that he's got SSDI, and just happens to tell you, and by the way, don't take too much offense to the way I act, I'm bipolar. He's got SSDI. Do you know if he's disabled? Yeah, it appears he is. Now, can you deny him based on the way he's acting as an applicant? Is he in a protected class, physical or mental impairment? Yes, he is in a protected class. One other scenario. Let's say, what's your first name? Mike asked a great question. So Mike rents to me. Unbeknownst to Mike, I'm a pretty bad alcoholic. And that was on one of the slides for disability. Or let's either A or B. A, recovering alcoholic, or B, recovering meth addict. Let's say I'm a great tenant for 2 years, but one night you get a call from the neighbor, hey, Mike, thanks for giving me your number because you told me if I ever had a problem with your rental to let you know I got a problem Cops just came and hauled your tenant out, and there were narcotics people out here, and he OD'd. I heard all these rumors that he was running a meth lab. Okay, here's the issue. Let's say I claim I'm disabled because I'm addicted to something chemical. Johnny Joe, mental illness. The law says, this is very advanced, so I don't want to get too far off on it, but let's just give you the nuts and bolts. Housing does not have to be made available to anybody who is a direct threat of harm to the health or safety of others, or themselves for that matter, or who currently uses illegal drugs. And I can tell you that does include alcohol. Okay, now let's break this down for a second. This does come up at some of the housing authorities because I'm very sensitive to the fact that sometimes you guys house people that may have significant mental disabilities. I don't know if Fort Collins does, but I represent quite a few housing authorities that this is a very real issue, and sometimes residents can be a threat of harm. So Johnny Joe, let's look at him, and then we'll come back to the example with the alcohol or the drug abuse. Johnny Joe. Now, that Fair Housing Act says, look, it's a two-sided coin. Here's the first side of the coin. The Fair Housing Act does not allow you to exclude somebody just based on fear, speculation, or stereotype. If I come in, I'm Johnny Joe, and I just kind of remind you of Jack Nicholson in The Shining, I look a little strange. Is that enough to say I'm a direct threat of harm to your community? No. But in the example we had, he's acting kind of menacing. The maintenance guy thinks he was a problem somewhere else. Flip side of the coin is you have to have a determination that somebody, an individual, poses a direct threat of harm. And that better be based on something very reliable, objective. Johnny Joe's situation, the maintenance guy says he was a bad egg at the last place where you just happened to recognize him. Is that enough? You passed your background check. Yeah, it might be enough, Brianna. Yeah, what if you get a rental reference, and I don't know how many landlords would go on the hook for this, but they say, be careful with Johnny Joe. He rented at our apartment complex last year, and 2 residents left because he was constantly screaming at them. You do need something pretty reliable. The maintenance guy, I put that in there because that was a real situation, kind of borderline. You better hope your maintenance guy is pretty credible about it, because otherwise Johnny Joe may say, you're discriminating against me because I have a mental disability. Alcohol and drug usage can be a disability if 2 things. Say it's me. 1, I'm recovering or recovered. And 2, the alcohol or drug usage has caused me to have a disability. In other words, an impairment. If you take other classes of mine, you quickly learn I'm a big fan of 70s sitcoms, like All in the Family, Good Times. Who remembers Taxi? Louie? Do you guys remember Jim, though? That was Christopher Lloyd, one of his early roles. Oh, Alex. There's a perfect example. The guy doesn't use drugs anymore, but he fried a few brain cells in the day, and it's obvious he's impaired, but he's not using anymore. He meets the definition of a disability. But what the government says under all these federal laws, the Rehab Act, the Fair Housing Act, is that if you're currently using, or you're a threat of harm through your use, or both, you're not protected. You do not have to provide housing to somebody that's a threat of harm. If you're uncertain, man, talk to counsel, your boss, your coworkers. These are complicated issues. Sure. The dog. Great question. Paris Hilton comes in. She's got her chihuahua, as my senior partner likes to call them, chihuahuas, chihuahua, in her arms, says, hey, this is my companion animal. Aren't these dogs certified some way you can verify whether they're real? All right, Jenny, call the pizza place. We're going to be here for a while. I'll give you the short answer. No. And Colorado Fair Housing Act says you cannot require certification of these animals. So real quick, I'll give it to you as quick as I can, just to recap. One name for animals that fall under these disability laws: assistance animals. Okay, assistance animals. 2 types. 1, service animals, who really perform some type of a function, usually, not always, but usually for a physical disability, the seeing eye dog. Some of you on break heard me talk about the case where the medical marijuana was coming through a vent, affecting the disabled guy's service animal, which highly trained dog tips him off to the things that causes seizures. I had a Rottweiler request one time, and I said to the manager, let's bring the Rottweiler down. The prospect, the applicant, there's your question about applicants, we had to see if we were going to have to take her dog. Service animal could dial the woman's phone if she passed out. She had some condition that caused a real bad blood sugar disability, where very severe type of diabetes, where she'll just go out. It was one of these cell phones, like you remember the Jitterbug commercials? You get the gigantic numbers on the phone. So I met the applicant with the client at the property so she could give us a demonstration. The Rottweiler dog can hit 911 on that phone and call the phone, and then all the local 911s know what number it's coming from, and they know who this gal is. Amazing. But does that dog have to be certified? No, not at all. And you can't ask a whole lot other than to get some assurances. Does that dog have to comply with your community rules if you allow pets? Or can you come up with some rules? Absolutely, but they have to be reasonable. The service animal cannot bite, attack, cause noise. But here's the key with animals. Again, a very advanced topic. They're no longer a pet if they're a service animal. Second species under assistance animal, companion animals. Those are animals that provide emotional support for mental impairments. You have to treat them the same way, but you got a lot of a lot of leverage to make sure the person's disabled and they truly need it and it's reasonable. I say, hey, I need Cujo to be my companion animal. Okay, Wes, what kind of dog is that? Well, I think he's mostly Rottweiler. Where's the dog at? Oh, he's watching a junkyard right now. That was last week, by the way. To which I said, and the client said, okay, why do you need Cujo versus a Pekingese or a cat? Or, you got a lot of right to understand why they need a particular dog, but you've got to treat them identical. And if you grant the request, they can prove that they're truly disabled, they truly need it, and it's reasonable. You have to waive any fees you would normally charge. You cannot collect deposits. Case walks in the door the other day, housing authority. Guy comes in, pet community. They do allow the pets at this one housing authority. He doesn't tell anybody that his dog's a companion animal. Just, hey, I got a dog, 40-pound mixed breed. Okay. Pays the pet rent, pays the pet deposit. A month later, suddenly, Fido becomes his companion animal. And that kind of goes to your question about, that you said splitting hairs. You have to take the request whenever it comes. And it can be a forgiveness versus a permission thing. You find him out walking his dog on the community, John, what are you going to do? Probably going to give him a demand for compliance for possession for breaching his lease. Then he comes in and says, if it's a no-pet community, oh, this is my companion animal. And you still got to consider the request. But anyway, in this case I was just telling you about, it converts from his normal pet to a companion animal, and he brings in a doctor's note. Client says, okay, we'll grant it as an accommodation and we won't charge any pet rent. Well, what about my deposit? Well, that will just hold in case the animal does any damage till the end of your lease. He marches down and files a CCRD complaint. Very good, Dion. And I think the client may have violated the law. I don't think it's a big damage kind of thing, but I think they needed to give him his deposit back. So the law is really clear. No, it converts. The minute you're dealing with an animal like this, they're not a pet. So remember, assistance animal, two kinds, service, companion, and there's no leverage that you can say they have to be certified. Paris Hilton, is she disabled? Be careful how you answer that. She brings you got a lot of leverage. Say she brings in a doctor's letter from her family practice doctor who treats her for sore throats and whatever else that says, Paris suffers from depression, and she says her dog, Fifi, makes her feel a lot better. I agree with that recommendation. I think she should have Fifi live with her at Happy Acres Apartments. Is she disabled? Good answer. No, we don't know from that letter. And that's why John at his outfit has a form for that. Doctor needs to say whether she's disabled. Now, I will tell you this. My personal bias is when it comes to companion animals, that's a mental health issue typically. And DOJ did say in a big case against Richmond Homes that you could request that that information come from a mental health care practitioners. So you do have a lot of rights there. It is a complicated issue. If you get one of those, you better make sure you got counsel that can answer it. I deal with companion animal and service animal issues every single week, and some of them are doozies, and we have to go through the three-part analysis. In the back. All right, so let's feed that question back. You get applicant A. This is an application question. Maria, you got a rental criteria. She kind of meets it all. Good FICO score. You get applicant B, Louis, and he's disabled, and right out of the gate, he wants you to take his companion animal, which is a mixed breed, and it's like a 50-pound dog, and he's pretty comparable to Maria, right, in terms of the application. You guys allowed to ask that hard of a question?
Or maybe even not so much.
That's a tough question.
Like maybe the income isn't quite there.
For which one? Which is the better applicant? Okay, well, you're saying they both meet your criteria. Can you take the non-disabled person over the disabled applicant? They're equal. Let's take two scenarios real fast, and I got to move on from disability and cover a few other things before we get you out of here. Scenario A, they're identical in terms of their meeting the rental criteria. Can you take the non-disabled applicant over the disabled? What's your policy? Imagine most of you take whoever applied first, right? I think you'd be okay there, because if the disabled applicant says, well, you didn't take me because of my disability, you better be able to show you got a policy first come, first serve. But what if one's a little stronger than the other financially? Let's say the non-disabled applicant's stronger than the disabled.
Only if that's your criteria, right? Like if it's financial, if that's your written criteria.
Yep. If you're going to deny the disabled applicant and she goes down to CCRD, man, I knew I picked the right person for the CCRD role. Great job, Dion. The question's going to be, I want to look at your exact rental criteria, and you better be able to articulate, landlord, that what your criteria is. And if your criteria is we're going to take the stronger financial applicant, I think you'd be fine. Because remember that test I gave you, you got a legitimate, non-discriminatory reason for why you took the non-disabled applicant. Great question, because I've never seen one like that, and if that was a real case, that'd be a tough one, kind of a close one. That's how gray some of this, tons of protected classes, right? Lots of them. Treat everybody the same. You cannot refuse to rent, make housing unavailable, set different terms and conditions. What if my friend here, the green jacket, I've forgotten your first name, that's Max. Fortunately, my short-term memory isn't a disability issue, just age. So Max, you rent houses? He does. All right, so he rents some houses out, and any that are close together, within a mile of each other? Okay. Several, yeah. So say you got two that are about the same square footage, and you rent one out for $700 a month, and you rent the other out for $1,000, and you rent the $700 a month to an Caucasian guy, and rent the more expensive one out to an African American. Do you got a discrimination issue? Are you setting different terms, conditions, or housing rates? Think that's discriminatory? Excellent. If I could show a history that I've been doing this, they've had different rental rates. And a lot of you immediately shook your head, no, that wouldn't be discrimination. You got legitimate economic reasons why you have different rental rates. Happens in apartment communities all the time. I had a case where resident A had a 2-bedroom townhome, and it was, say, $900 a month. He's an international lawyer from Jamaica, black, and he finds out his white neighbor has a 3-bedroom townhome who's only paying $650. Kind of looks discriminatory at first, right? But what would we need to know, Dion, down at CCRD? We'd want to know a whole lot more about that scenario. And the truth behind the scenario was the Jamaican guy moved in 1979. I'm always amazed when clients have had tenants that long, but he'd lived there a long time. And the white guy that he was comparing himself had moved in the year before. You think the rental markets were a little different from 79 to 2008? Yeah, gigantic. I mean, if I moved in 2003, that might be a lot different than 2009. In Denver, in 2009, the rental market had got so bad, thank God it's kind of coming back, but I saw signs around town that would say first month's rent. I got one even better for you. : make offer. Yeah, in Bear Valley, Lakewood, I saw one that said that. So I get in on a rent special, and the other guy was back 7 years ago when rents were a lot different and you got a much higher rent. Is that discrimination? No, you got a legitimate economic, non-discriminatory reason. Okay, good. But these are the things you can't do that will result in discrimination. And we said early on, one of our goals was to understand discrimination. Can't falsely deny housing's available or deny access to membership in a facility of service. All right, I think we've already covered this, but unless you're exempt from the fair housing law, it applies to you. And the only thing I'm going to say about exemption, it's a hard thing to remember, but you have to own very few things to be exempt. Like if you own under 3 single-family homes and you didn't have a broker or a leasing agent help you with the transactions, you might be exempt. I actually won an exemption case last year for a client out in Steamboat, but it was the first time I ever saw anybody exempt because most people use a realtor or an agent to manage the property or buy it for them, help them in the listing buying process. Almost everybody has to comply. I did if, let me see if I can remember this because I know you're going to want to write it down. I always have trouble remembering the exemption because it hardly ever applies. If you own only single-family homes, not a duplex, so only single-family, you have to own 3 or less, and you can't have used a broker in any of the transactions or have a property manager to be exempt. Duplex would fall under a second category where you own a building with 4 units or less and you live in it. You could have, if you only owned a duplex and you lived in one part of it, you would not have to comply with the Fair Housing Act. But let me just say this. I don't want anybody to get too excited about that because you got to really look at the finite parts of the law. I think the best advice I can give you is it always helps to know that you're really complying with the Fair Housing Act. But yeah, there are 2 exemptions. Single-family homes, if I remember it right, it's 3 or under. If you own 4 or more, you're not exempt. It might be 5 or more, but I'm pretty sure on the 4. Just nobody really asked me that too often, but I'm glad you did. So 3 or more under, but you've never used a broker. And if it's multifamily, it has to be 4 or under building, and you got to live in it. Somebody else had a question, I think, on that. All right, good. All right, kind of branch into, and everybody has to comply. I mean, some of our management companies we deal with, like Brianna works for Associa, they have higher levels of people in them. Everybody has to comply. Oh, there's the big L. Donna was on to something there. There's the big L. Legal penalties. So we've been talking about CCRD and HUD and who they are and that you can have issues if they go down and they file. If you're found liable for discrimination, they can issue fines, and it can be up to 10 grand for your first offense, 25 large for a second, and 50. They don't always impose them, but they will threaten you with it, so you'll settle the case, and you just do not want to be found liable. How long do you think somebody has to come after you on a fair housing allegation to go to the Colorado Civil Rights Division or HUD? Because they can go to either the federal government or the state. Now, that is not a lawsuit. When I get these CCRD complaints in the door, they're not a lawsuit, but what they are is they're an administrative complaint. And in the scenarios we've been using Dion as our investigator for, the investigator decides whether there's been discrimination. And if she finds that there is, and the director of the agency agrees, they can issue these fines, and then they can do what they call charging the complaint, and they set it for a hearing, and that's just like a lawsuit. It's just that it's administrative. They bring in an AG attorney from the Attorney General who will try the case in front of an administrative judge from the state of Colorado. So you don't want to lose these things if you ever get hit with one. How long does somebody have to bring a CCRD or HUD complaint against you? What do you think? A year? Great guess. Great guess. 1 year to file with HUD or CCRD from when they feel you discriminated against them or maybe denied them a reasonable accommodation. But they can also sue you in court, which is different than HUD or CCRD. This is why understanding the law, being able to defend yourself to show that in no way have you discriminated against somebody is so important. In my world of employment law, it doesn't work like this. If I defend a company and they fire somebody and the employee says, hey, I want to sue you under Title VII. That was that 1964 act in one of the early slides. They got to go down to a similar agency like HUD called the EEOC, Equal Employment Opportunity Commission, and they got to do that before they could ever sue you. They got to go through that process. It's called a duty to exhaust administrative remedies, but housing's different. If I want to go down, I'm mad at you guys because you wouldn't let me have my Shetland pony. I can go down, see Dion, CCRD. She can file a CCRD complaint, and I can run over to the federal courthouse and file a lawsuit against you. Or I could run over to Larimer County District Court and file a lawsuit, and I can do both at the same time. Or I could file the lawsuit first and then do CCRD, or I could do the civil suit later. And if I want to sue you later, I got 2 years from when I think you discriminated against me when you said, no, Wes, you can't have that Shetland pony. I got 2 years. And that 2 years the clock's not ticking while I'm down at CCRD waiting for a decision. So that means maybe they don't even go to court against you for 4 years. Why is that important? Keep documentation as long as you guys can on your residence. How many people archive your stuff? Good. You want to keep this stuff on file. Okay, so they can bring a CCRD complaint or a lawsuit or both. So you just got to be aware of that. CCRD does a really good job. The problem is the state statute in Colorado is written that they pretty much have to take anything that comes in the door where somebody's alleging discrimination on some protected class basis. And they only find against landlords probably about 90-95%. They only find against landlords a small percentage of the time, like maybe 5, maybe 7. HOAs are higher. But property management companies that do landlord usually exonerate themselves. But boy, be ready to show that you did not discriminate against. Okay, a few other areas to cover. Sleepy Acres. Remember that HOPA law we talked about earlier? They run an ad, hey, our community is ideal for retirees. Is this okay under fair housing? Sure it is, somebody says. Who thinks it might be a problem? And what area of housing does this relate to? Max? You are on the money. Max said, hey, if this building houses mixed people, older, elderly, disabled, younger kids, is that a problem saying we're ideal for retirees? Okay, what area are we talking about here? Yep, protected class, and this is an ad. Who in the room here is responsible for advertising in your profession? Raise your hand. Gary, you didn't raise your hand. Gary's like, okay, Gary, do you place ads in the paper? Yeah, you're responsible for advertising. Housing Authority, do you tell people how your communities run? Do you market them? Absolutely. In some way or another, I think I could argue all of you are responsible for advertising in one way or not. All right, so here is the law under fair housing. You cannot state or imply any preference for or against a protected class in an ad. You probably should not advertise senior-based communities, independent living. Anybody here have senior communities, housing authorities? You guys do? What do you mean, kind of? What are the ages of the people that live there?
Anywhere from 20 to...
Okay. The only time...
Like 40% are...
All right. Well, you really don't have a senior community because, again, you have to have 62 and over, or you have to have a 55 and older type program. And to be a senior community, you kind of have to start out as one. It's hard to change and become one. But senior communities that advertise as independent living, CCRD doesn't like it, HUD doesn't like it too much because it's sort of saying, hey, you got to be independent. Don't be asking us for modifications, seniors. Maybe a preference against disabled. That used to be a little bit more scary issue, but not a big deal because most senior communities either say, hey, we're a senior community or retirement. Can this outfit say we're ideal for retirees looking at these rules? What do you think? Max is right. It's questionable. What do we need to know? Outstanding. Great job, Max, because you brought up mixed. Great job because you're saying we need to know whether it's mixed. If it's truly a senior community, might be okay. I think there's better ways to say it. This is a senior community. I guess you could advertise as retirement, but if it's mixed, who's there a biased against if it's mixed? Anybody younger, families with kids? And that could be a problem. Describe the property, not who might be living there. Let's say you open the paper and there's an ad for Tamarack Heights, and it says, ooh, close to the synagogue and all public schools. Is that okay? Why is that wrong, looking at these rules? Donna? Implying religion. Down here it says don't use religious symbols. I saw an ad in the Denver Post the other day with the fish. What's that implying in an ad? We want Christians to rent from us. That's a big problem. Back to my question, Donna hit the nail on the head. Synagogue, boy. Describe the neighborhood in general terms. Saying the synagogue there might be viewed as expressing a preference for Jewish applicants. Max. Ooh, great question. Near the school, who thinks that's okay? Near public schools? I think it's okay too, but great question. Doesn't that show a preference that, hey, we want people with kids versus singles? I think you'd be okay on that. But let's use this as the test. So I got a client, told you about a little bit ago. He won on an exemption thing because he only owns 2 single-family homes and has never used a broker to rent them out, to buy, purchase. He did it all on his own. Very few people meet that definition. Property out in Steamboat, he ran an ad. Now he's got 2 houses on the land. It's a really cool piece of land. It's called like a dedicated deed. And he can't build fences. He has to allow wild animals to come in and through it. Who's been to Steamboat? Anybody been to the hot springs there? That strawberry place? It's right by there. So he has a carriage house on it, and he rents it out to a caretaker. He's a retired surgeon. Him and his wife live there about maybe half the year. So the other half the year, they want to make sure there's somebody there to take care of the land. So what he wanted was to make sure that he had somebody there because he put in the ad that they're an empty nest couple and need a caretaker. Some gal who Max would do a background check on her, find out this gal's a problem. She's what in my world we call a shopper. Well, that's a shopper. She's somebody looking to nail you for a fair housing violation. She calls him up and says, hey, yeah, I'm interested in this caretaker property, and I've got 5 dogs and 3 kids. And she claimed that he said, well, I don't take kids. The ad didn't say anything about kids. It just said, empty nest couple seeks applicant for caretaking. Now, she filed a complaint with HUD. And HUD looked at it. They got some buzzwords in advertising they don't like. Empty nest is a bad word because it would imply, hey, we're looking for only people without kids to rent. That would be a problem in advertising. But was that what he was saying in his ad? If you were listening to me close? No, what was he saying? Yeah, exactly. They were the empty nest couple. But boy, I was worried about that one because here's where exemption's also a problem. This is why I don't like talking about exemption. He only owns those 2 houses. He's exempt. But you know what the federal law says? You're not exempt if you make a discriminatory statement. Then you blow your exemption even if you were exempt. And that's what she was accusing him of, a discriminatory statement in an ad. So the only way I get him out of this is to prove, 1, that he only owns the 2 houses and didn't use a realtor, and 2, he didn't make a discriminatory statement, and that buzzword was in there. Okay? So somebody help me argue this. What would you argue that this isn't a discriminatory ad? Looking at all these things. It's all about a preference. Lady's saying, well, you're showing a preference that you don't want people with families and I have dogs and kids. And she claims he told her no kids. What he put in his affidavit to CCRD was no. I asked her if she has kids because we just inquire whether somebody has kids, because we have wild animals coming in and through the property because of this special deed. And I didn't tell her she couldn't have kids. I just wanted to know if she did after she inquired. That could be a no-no, because you're really supposed to only ask how many people will be living with you. But let's work this thing through. We were accused of advertising discrimination. No way, I'm going to go to you. I like that you shook your head. What's your first name? Jason. Thank you, Jason. You're saying no way. So you're my client's lawyer here. All right, you got to argue this to Dion, so we'll see what Dion thinks. It's down at CCRD. Is the ad discriminatory? Does it state or imply a preference for or against member of a protected class? All right, I'll be her. Dion, it does, because he wants empty nest couple, and he doesn't want kids. Jason, argue for the landlord. Outstanding. The empty nest is referring to the landlord, not who he wants to rent to. Okay? And we ended up, by the way, showing that the last 4 caretakers all had kids. All had kids. No bias against children. Even though it's touchy to ask for kids, he had a legitimate, non-discriminatory reason. Why, Dion? Safety. This is a unique property. Okay, Jason, take it one more level. This empty nest is a buzzword that HUD doesn't like, so how did he get around that? Let's just think it through. If that buzzword, empty nest, is a problem, and I'm this gal, right, and exactly, Jason, he applied it to himself, and if that wasn't clear, would she have even called him? The idea of this buzzword is would discourage somebody from applying. Synagogue, oh, well, I'm not Jewish, so I won't call on that rental. I'll go to the next one. That's a problem. But if she thought it really meant that he didn't want people with families, why the heck did she call him? I made that argument, and I was astonished. CCRD absolutely agreed, Dion. They said, not a discriminatory ad, he's exempt, case over. I was really happy about that one because it did make me nervous. I'd never had an advertising case. So the best way to stay out of all this is to be very general. Don't use symbols. Don't use the word empty nest at all. If he'd have just avoided that. And can the paper be held liable up here in Fort Collins if they put those words in? Jenny, what do you think? Yeah, in an ad. Think the newspaper could be held? Yes, they can. The CCRD HUD can name the newspaper as well. One area where the advertising agency has to be careful. Okay, sure. Okay. You are asking me a brutal question. She is saying that her sister bought a property in Manitou. Everybody know where Manitou is? By the Springs. And the city says it has to be 48% senior? Interesting. Never heard of that. Believe it. Definitely believe it. Cities come up with some interesting things, as Fort Collins has with this unrelated thing that I find kind of mind-boggling. All right, it has to be 48%? Yeah, so can she advertise to get up to that percentage? I think so. And then if I come and say, well, you didn't take me because you got a discriminatory ad, I think you might be able to defend it because you're trying to comply with that ordinance. That's one of the most bizarre questions I've ever heard. I am going to go research whether Manitou does that, because it sounds like they do. Yeah. Yeah, maybe there's very little parking, so they're trying to get elderly people. That just is mind-blowing. But, well, if you had to meet an ordinance for a certain kind of housing, then I think you can get around fair housing on that. And we've got something here in a second that'll really bring that home. A couple other points on advertising. If you have flyers and stuff, you need to use people of different races. A gal sent me an email one day saying, hey, this is my flyer. It was really cool. Color, print, attachment. She goes, do I have enough diversity in here? Really nice lady, but I looked at it, and very savvy manager. And I'm like, okay, it's a couple, white, with the kids, so I guess you got familial status, but you don't have anybody else in the picture. So what did I say to her? Throw some other people in the ad. Keep records that show you have neutral policy. Rental criteria, you guys all have your criteria. You need to follow it. We've hammered that home today. You got to be consistent. We've hammered that home today. I love this little bullet point. Personal feelings aren't allowed. You got to be careful. Point there is one thing all of us share in this room. You manage property like Donna, like Brianna, like the housing authority, you have some pretty rough days in the job, don't you? Conflict, tough situation, same as my job. And you know how I feel about it? You don't get to have a bad day. And we all have them, but you can't come into work at 9 o'clock after you've had a fight with your husband or your kid, your fiance, and be grumpy to some resident. I'll get to your maintenance request when I can. And then at 10:30, he's still hanging around seeing if you're going to help him out, and he sees another resident come in, and you've had your coffee, talked to your colleagues, you calm down a little bit, then you tell a different resident, oh yeah, Martha will get right after that drippy sink. You know, that's where consistency comes in. You have to be on your game. It's really important in housing. All right, cyber and telephone profiling are the next big area of fair housing. What's that about? Who does electronic applications here? Anybody? Nobody? Okay. A lot of our clients do. And they got to be careful. They got to treat them just like they're in writing and not sift through stuff by name, last name. A big no-no. You got to treat it just like you would anything else.
Hello. Yes. Can I ask a few questions about the apartment on Park Street?
What was your name?
My name is Juan Hernandez.
It's been rented.
Oh, it's gone. Hello, my name is Sanjay Kumar. I am calling about the apartment on Park Street.
It's not available.
Not available?
Hello, my name is Tyrone Washington. I'm calling about the apartment on Park Street.
Just been rented.
Hello, I am Chen Ling. My name is Khalid bin Ali. I'm Tuan Vo.
Hello, my name is Moshe Goldberg.
I use a wheelchair. It's gone. Not available. All right. Thank you.
Yes, hello, my name is Graham Wellington. I'm calling about the apartment for rent on Park Street. Is that still available?
Yes, it is.
Oh, it is?
Yes.
Really?
Housing discrimination is illegal. If you think you've been a victim because of your race, color, national origin, sex, religion, disability, or family status, call us. Fair housing. It's not an option. It's the law.
HUD ad. Everybody notice the phone there? I pointed to it, kind of older. So I did some research on when they did that ad, obviously some years ago. The guy's like Rich Little there, lots of imitation. And he's Grant Wellington III. Oh, sure, it's available. I saw that ad last year on a Fox station. HUD's still running it. Why would HUD still run it? Because this stuff still happens today, or I don't think they'd run it. So a great example of what you cannot be doing in this day and age. Hotspots, hey, owner's dream, always occupied, 90% full, 99% full. They got a great website too that generates a lot of applications. So I know a lot of you aren't doing electronic stuff, but this place is. But man, even without all that electronic stuff, the leasing office is crowded. This guy just can't keep up. So sometimes applications sent via email are the last to be dealt with. Is this a fair housing violation? Yes or no? Yes. If I'm your leasing agent, Brianna, at one of your communities, and I meet the people over there, what do? Bring them in the door, show them the place, greet them. You got to do the same thing with an electronic application. So if you ever get into that, you got to deal with them. Can you just take the first person that comes and not take any other applications? Dion, I know you got the answer. You have to treat all applicants equally. But if you got a policy, well, what do you mean, Max? Like the first person out of the gate meets your criteria? I think that's okay. But my suggestion, have an internal policy that says first approved, first in the door. And I think you're okay. Email. Who uses email here? Oh, come on. Nobody raised their hand. We just don't want to admit we use email because why? It beats the crud out of us, doesn't it? I could sit around and work email all day long to my chagrin. We all use an email, aren't we? A lot. Kind of a big deal now. So you got to kind of be careful with email. Man, I'm notorious for this. I forward emails that I don't realize somebody might see. You could create a fair housing violation, so be careful with email. Sometimes it's like thinking out loud. You should probably reread them. Occupancy. Let's talk about this, and then we'll kind of wrap up. You guys have an interesting ordinance up here, don't you, about occupancy? How many people can live in a unit? And those of you that really know, what is that? So many people per square feet? No? Well, I know you got the 3 unrelated, but you also have got a square footage occupancy. 100 square, right, Jenny? 100 square foot per person? The guy that talks for you before me when I do the 1 hour, what does he cover? Okay. So you have to comply with that. And if somebody is a family and they got too many people, are you going to be accused of familial status if you're complying with that ordinance? No, you will not. So I told you I'd cover that. I'm going to skip that because that's more 2 people. Real quick, Amy, college student, says, man, I can't wait to move into your place. My last place, I'm a serious student, unlike these jokers I lived with down the street by the university. They were so loud, partied all the time. Can you tell me, Brianna, about my potential neighbors? Is it going to be quiet here? I need to get some rest and study hard. Can Brianna tell me? Why not? What aspect of fair housing is this? Anybody know the word? Confidentiality is getting close. The term is steering. Yeah, that's been around for a while. Steering is trying to direct certain people to live in a certain place. Doesn't come up much, single-family homes. Back in the day where landlords and realtors worked to do block busting, I mean, like, who was a kind of a fan of All in the Family? I was. Show was great. Archie, before the Jeffersons moved in, they tried real hard to keep the Jeffersons out. They worked with the realtors. That's blockbusting, highly illegal. Steering fits into that. You can't steer people. Defended an allegation one time that, our client was directing all the people into the East building who were minorities and giving all the whites to the west side of the building, and west was Shangri-La, great pool, crappy pool over here. We showed no. Both buildings highly diverse. Yes, the pool over here was bad because it was going to take 15 grand to repair it, so we allowed everybody to use the pool over here. There was no steering. But some people do steer. Big no-no. Talked about lease documents. You lease to a baseball team? 3 members of the baseball team. The pitcher, the catcher, and the cleanup hitter. He's expecting a few problems. So, he steered them out. Is that a violation? This is a part of fair housing that's so hard, and I kind of want to end on this and let you guys get out of here. So we've been talking about things that are really intuitive, common sense, but here's something that's a little counterintuitive. He just wants to help these people not rent the wrong place and be next to Todd Helton and these guys throwing balls against the wall, and maybe they're kind of partiers. So can he tell them about them? No, that is steering, and you even use the word. And that's kind of counterintuitive. You're just trying to help people, but you really can't do it. If I come in, I'm disabled, and I say, hey, take me up to the 2nd floor. I want to see that unit. And you're like, well, the elevator's down. Well, my realtor will carry my... Can you say, well, we got really great units on the 1st floor that are accessible. Can you do that? No, you got to show everything, and you have to just kind of, and if I say, what kind of people live here, you say, anybody who qualifies and meets the criteria. Question? So let me see if I understand this. And this was at a housing authority? Oh, he just thought like you guys could give him some advice, as if the housing authority's legal counsel. So he asked if he could do what? Who thinks that's steering? I'm not even going to regurgitate that one. I think that's probably steering. I don't like it. You got to stay away from that. So we talked about different rental rates. Oh, hey, what if across the street, let's say we're renting a place right here, and across the street's a widget factory, and we say, hey, widget people will give you a discount. Is that okay? Actually, it is, as long as you got a legitimate, non-discriminatory reason, because maybe that's going to give you some good rentals. But here's the rule on it. You must document the dates. It's got its risks. Senior corporate discounts, very risky. There's a HUD memo on that. You better make it available to everybody that applies. So if 5 people come over from the widget, don't just give it to the widget factory. Don't give it to only 4 out of 5. I always thought widgets were a fake thing because they always used it like in law books. But I found, those Guinness cans, the Guinness beer, they got widgets in them. All right, we'll end on this. Employees, if you got people to work for you, got to get them up to speed on fair housing. Anything they do will bind you. Who can be named down at CCRD or in a lawsuit? Very different than employment law. Anybody involved, I say the maintenance guys didn't fix something for me, they can be named the manager and the management company and the owner. And every one of these I defend in front of the CCRD, that's who they name. And you should just be consistent all across the board. Maintenance requests, how do you guys deal with your maintenance requests? Immediately, even-handedly, you document them well, and you should be okay. So remember my point of view about fair housing. I think one of the things I was worried about when I moved to the area I was in, that my child wasn't going to be in a diverse area, but remember the first day at kindergarten, he was around an Indian girl, African-American kid, just mixed kids, and it's just so cool to see the way they interact. He was 5 at the time, doesn't see any differences, and it's so refreshing. And I think, it's just all about seeing people as people. So, in ending this, you got to know the rules, but like I said, don't walk out of here thinking it's just eggshells you got to walk on. You can always go back and look at them. Be consistent. Make a commitment to fair housing. Keep getting education. See people as people, and that's most of the battle. All right, well, I've had a blast with you guys. That was you're a fun group. Really appreciate it. I'm going to shut down here, but if you got questions, be happy to answer them.